Good morning, folks. This is the Colorado Oil and Gas Conservation Commission. It is October 6th. It's 8:30 in the morning, and we are convening our weekly agenda. We did have an edit to the agenda, which is that we do need to go into executive session briefly to receive legal advice concerning the enforcement docket. And with that, I will start by asking for a roll call, and then we'll turn to AAG Lauren Mercer.
Thank you, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez.
Here.
Commissioner Hackett. Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Very good. Okay, we will move into our weekly agenda. The first item is the potential for an executive session. Would turn to AAG Mercer.
Thank you, Chairman Robbins. Pursuant to the Open Meetings Law, the Commission is entitled to enter into executive session at this regular meeting for the purpose of discussing, receiving legal advice pursuant to Colorado Revised Statutes, Section 246402(3A)(2). The topics of the executive session were identified on the agenda for executive session. They are to receive legal advice as authorized by CRS 246402 regarding enforcement docket numbers 191-200-688, 191-200-755, 200-700-198, 201-100-264, and 210-800-133. The Commission will not deliberate, make any decisions, or vote during the executive session. Chairman Robbins, I invite you to encourage a motion to enter into executive session for the matters and purposes I just named.
Very good. Thank you, AAG Mercer. I so encourage a motion.
So moved. Second.
We have a motion and a second. Any further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Opposed? Very good. For our stakeholders and our participants, we will now be leaving this Zoom meeting. We will Zoom together in an executive session with just the members that are present. Once we are done, we will come back to you and we will resume the general session with this Zoom meeting. We anticipate this will probably take about 20-25 minutes, so we hope to get back here at about 9 o'clock. We look forward to seeing everybody at that point in time. Okay, folks, welcome back. This is the Colorado Oil and Gas Conservation Commission. We have now left our executive session Zoom. We're back in our general meeting, and I call upon AAG Mercer to tell us what we need to do next.
Thank you, Chairman Robbins. We are returning from executive session. During executive session, the Commission received legal advice on the enforcement matters listed on today's agenda. No decisions were made and no votes were taken. Chairman Robbins, I invite you to encourage a motion to exit executive session.
So encourage fellow commissioners.
So moved.
Second.
We have a motion and a second to exit executive session. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Seeing none, we have now exited executive session. Anything further from you, Ms. Mercer?
No, Mr. Chair, nothing else from me.
Okay, let's give ourselves just a second. Hearings manager Larson is not with us just yet, and it's kind of ironic that she's not the one that's in the Zoom because she's so good at it, but I just got a text that she's trying to get in. Ms. Amaro, if you're with us, can you see if Hearings Manager Larson is in the attendee group? I don't see her there. Oh, there we go. See, she's connecting. Okay. I think we have everyone on board. Good morning, Mr. Hackett. See you as well. Let the record reflect that we've got both Mr. Hackett and Ms. Commissioner Bogue in attendance as well. So we have all 7 folks in attendance. Before we move on to our agenda, does any commissioner have any comments that they would like to make at the beginning of our agenda before we move forward? Commissioner Nanjapa?
Thank you, Mr. Chair. I did have a couple of things I just wanted to bring up. You know, we heard back on August 13th, a matter related to payment of proceeds for David and Paula Wingfield. And we issued an order number 1-250, ordering CWC Petro to pay them the amount that they were owed, $16,041.02 plus interest. And we did get an email from Mr. Wingfield recently that was past the time frame that we had requested in the order for CWC Petro to pay, and they still have not paid. And so I looked into a couple of things in our database and asked a few questions, and it seems like there's some matters out there that could use some additional investigation to better understand what's happening with CWC Petro and why they are not paying as ordered. You know, we often hear that one of the many benefits of oil and gas development is the royalties that the mineral rights owners receive, and so this is very troubling to me. And so, although we don't have the ability to you know, garnish bank accounts or pursue them further, I understand that they've at least been informed that, you know, they can take up the matter directly with the courts, the Denver District Court. But I would like to put forward a motion under Rule 503A, to initiate an investigation and proceedings into CWC Petro and to understand further just more about their compliance overall here with the commission, with our rules, et cetera. And so if I may, Mr. Chair, I'd like to put forward that motion.
AAG Mercer, if you could join us ever so quickly. I just want to procedurally ensure ourselves that such a motion that was not on our docket is appropriate at this point in time.
Yes, Mr. Chair. So under Rule 503A, the Commission may, on its own motion, initiate proceedings upon any question related to oil and gas operations in the state of Colorado. And so I believe that such a motion and vote is appropriate without having been noticed. I think, you know, any hearing or other formal proceedings that may come out of this motion, those will need to be properly noticed. But I have no concerns with moving forward with Commissioner Nanjapa's motion.
Thank you very much. Commissioners, we have a motion before us. Is there discussion on the motion or a second?
Second. Mr. Chair, sorry. Oh, I was just I have a more formal motion. I have some language I can read just to formalize this a bit further, if that's
perfect.
So I move pursuant to Rule 503A to initiate proceedings upon the question of whether CWC Petro has complied with Commission Order 1-250, the Act, and Commission rules. Specifically, I move to instruct COGCC staff to conduct an investigation into CWC's compliance with Order 1-250 and the COGCC rules during the time period from April 2020, which was when the Wingfields first alerted the Commission to the payment of proceeds issue, up until present. If staff has reasonable cause to believe violations have occurred, then they should commence an enforcement action by issuing NOAVs within 30 days or as soon as possible, and then moving those NOAVs through the enforcement process to a hearing before the Commission within 90 days of issuing the NOAVs or as soon as possible. In pursuing any enforcement violation, staff should consider the full range of appropriate relief.
Is that
That was
the
the
sum
motion.
total of your motion?
That is the entirety of the motion. Thank you.
I'll second it, Mr. Chair.
Okay, we have a motion and a second. Do we have discussion on the motion? Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Commissioner Nanjapa, for bringing this up. I was asking staff some pretty similar questions about what our options were to kind of try to figure out what was happening here and why there was not responsiveness to our commission order. And so I'm supportive of this motion and finding out what's happening with this operator and seeing if we can get compliance.
Thank you, Commissioner McGowan. I, for one, would like to call upon Director Murphy to get some sense of staff's thoughtfulness about such a motion. I am aware that, generally speaking, based upon the order that we've created, the person that has not received the royalties now has a right to go to court, and that generally the commission itself hasn't furthered that right with investigations or other things. Instead, we've sort of sat and said, it's now up to you. You can go to court, you can get attorney's fees, you can do everything you want. So this is a little bit of a step that is new for commission, and I'd like to hear from Director Murphy relative to her thoughts on the motion before we take a vote.
Thank you, Chair, for the opportunity. It appears that both staff and the commission were pretty aligned in this. I know that we've been working hard on 5 NOAVs, I believe, against this operator. And so I think that these two efforts complement each other in this instance, and we'll proceed apace, I think.
Thank you, Director Murphy. Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you, Director Murphy. That's good to hear. And I just to note that in kind of doing a little bit of investigating in Cogcc, I did find that there were reports that were missing or that were apparently delinquent, and a few other matters that appeared to be not in order. And so that is again the nature of the motion, to be an investigation to find out whether there's more going on.
Commissioner McGowan.
Thank you, Mr. Chair. And in talking with our staff, I do understand that the mineral rights owner has the option to go to court, but I also think that, if I'm understanding correctly, the operator is in violation of our order, and we do have the authority to look into why potentially this operator is in violation of our order, which is to me a little different than saying to the mineral owner that they can go to court to try to get reparations.
Further discussion on the motion? Seeing no further Commissioner Gonzalez, get in there, tip in.
Yeah, a quick comment, Chair. I agree with that analysis. This is more just than enforcing the enforcement that we've ordered. It's really to hold the operator to account for the violation of our order. And so in that regard, I appreciate Commissioner Nanjapa's motion, and I plan on voting in favor of it. So it's my discussion.
Very good. Any further discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Any opposed? Motion carries. Director Murphy, you are so instructed. Go forth and investigate, and we'll look forward to hearing from you.
Thanks, commissioners.
Okay. So normally we do our commissioner comments toward the end of the agenda. I'm sort of thinking I might move that sort of on our own to right now. One of the reasons for that, and one of the reasons I ask you guys if you had comments, is that we generally have more attendance at the beginning of our agenda than at the end. And so I think if we have comments that are important for folks to hear, doing so now would be appropriate. I do have a comment that I think is appropriate for everyone to hear, and it also is a ask of the commission. As you know, I have been designated hearing officer on the KPK enforcement matter. I wanted to report back to you that we have had multiple meetings with staff and KPK working on a compliance plan that is in comport with the direction that we received from the commission following the KPK enforcement hearing and the pattern of violations matter. I can attest that it is complex. I can attest that both the staff as well as KPK, as well as myself, have been working hard at the complexities associated with the compliance plan. I can attest that I think we are gaining ground toward a volitional approved compliance plan that everyone will agree to. I can further attest that we ain't gonna be ready by tomorrow morning. And apologize for that, but it's not for a lack of effort on the part of all the individuals that are working on this. We have some calendaring issues with regard to commissioner calendars, as well as some of the calendars of the parties. And so at this point, we are likely, and Ms. Larson, I apologize, I don't have my notes in front of me, but I think we are wanting to continue this to a commission hearing of October 27th. Did I get my date right, Ms. Larson?
Yes, that is correct.
And that will afford all parties the opportunity to continue to work hard at a compliance plan that we hope will end up being an agreement between KPK staff and then ultimately for this commission as part of its order. I remind everyone that if we don't get to agreement, then the commission retains its right to order a compliance plan, and I've reminded folks about that all along. The time frame is as a result of the need for some additional effort to work on this, and also accommodates the fact that we've got some commissioners out of office, and I want everybody to be available to be able to hear this. So I don't know that we need to do anything formal other than just alert our webpage that tomorrow's hearing would not happen. And instead, we would have a hearing on October 27th, in which I'm hoping that I will bring to commission this compliance plan. And well, here's the thing. I'm going to either bring a compliance plan everybody's agreed to, or I'm going to bring a compliance plan that is something that I think we should order to happen. So one of the above will happen. I also would note that staff and KPK are actually meeting, I think like right now, to go over some of the corrective actions that are due by like this Friday. So they're still moving forward on some of the Form 27 asks and needs. And so that all is still happening. And so we're not losing out on anything by the couple of week delay. We're still mandating that KPK live in accordance with its Form 27 obligations, et cetera. So nothing's slipping as a result of the date being changed. So I'm happy to take any questions from commissioners on that. Otherwise, I will instruct staff to go ahead and cancel tomorrow's hearing and move forward with the October 27th. And we're hopeful to be able to bring that to everybody on that date. Okay, I'm seeing no questions. Thank you very much for your attention to that. Does anybody else have any commissioner comments they would like to lodge now? We'll do another commissioner comments toward the end, but anything else for the good of the cause before we move into public comment? Commissioner Hackett.
Thank you, Chair Robbins. And just wanted to highlight for folks, we did give, myself and the other commissioners gave a presentation last Friday to the Regional Air Quality Council about COGCC's efforts to minimize ozone precursor and greenhouse gas emissions. Just wanted to thank commissioners for participating in that and helping field questions at the end. I have received some positive feedback from the RAC about that, so just wanted to relay those kudos from RAC members for your involvement last week. And then also, I'll make sure to flag this closer to the Air Quality Control Commission's October 21st and 22nd hearing. but there's going to be several briefings that's going to be of interest to commissioners and members of the public who are listening in today. One of them will be a review of the 2021 ozone season. The Air Division will present data from this year's ozone season, and we'll kind of get a little bit of a similar presentation from the RAC about what their emissions incentive reduction programs are. And then another item that will be presented that week is a briefing on the natural gas transmission rules that the division adopted in December of 2019. And there will be another rulemaking hearing, something that doesn't directly concern COGCC or the oil and gas industry, but also relevant to the bigger conversations we're having at the state on how to reduce greenhouse gas emissions. There's going to be a rulemaking hearing on industrial manufacturing greenhouse gas emissions, and just wanted to note that for people early so people can mark that on their calendars, and I'll make sure to bring that up again closer to the hearing. Thank you for that.
Thank you for the consistent updates about our sister agency, Commissioner Hackett. We really appreciate it. Any further comments from folks? Okay, I'm seeing no one unmute, which signifies that we're probably done with this round of commissioner comments. Thank you everybody for bearing with us on that. At this point, we will move to general public comment. And I would note a couple of things. First, we do have 2 OGDPs on our agenda, on the OGDP consent agenda. I anticipate running that like we ran our last one, which would be that we would have an opportunity from the operator to present shortly, staff to present shortly. And if there are any public commenters that desire to publicly comment on an OGDP that's on our agenda, please refrain from public commenting now, and we'll give you an opportunity to public comment at that time so that we're hearing all of the information around the OGDP consistently at one time. Secondly, I would like to point out that we have 7 people that have signed up for public comment. We'll go through the list here shortly. Everyone will receive 3 minutes for public comment. We look forward to your abiding by that time frame. If we're fortunate enough, Ms. Amara, one of our hearings managers, will put a timer up so that people can know what time they have left. And then finally, we always appreciate when we receive written public comment. We did receive written public comment this week, and I'm going to read off the written public commenters so that they can know that their written public comment was received and was read by commissioners. The following folks provided written public comment: Amy Allen, Janice Brown, Scott Simmons, Lynn Lowry, Kelsey Barnholt, Hazel Gordon, Lori Rochard, Pauline Miglor, I apologize for that, Karen Calavity, Kate Christensen, and Tiffany Rappleton. So thank you to the public commenters who provided written public comment. It is appreciated. And with that, would look to hearings manager Larson to help us run through public comment. I believe we have Heidi Leithwood as our first public commenter, and it looks like she's been elevated to the panel. Ms. Leithwood, if you want to unmute, and we can actually see you as well. Good to see you again. And you have 3 minutes.
Okay, good morning, commissioners. I won't be able to see the timer because I have my notes up on screen, so I apologize. I'll try not to go over. Here's the short version of my comments. In 2019, oil and gas systems in Colorado emitted 21.930 million metric tons of carbon dioxide equivalent greenhouse gases. This is from the 2021 GHG inventory report. The social cost of carbon equivalent monetary figure of the damage of those emissions is $1.644 billion for that year, and the Act requires you to hold the operators responsible for all adverse effects of their emissions. Here's the long version. The social cost of carbon, or SCC, is an estimate in dollars of the economic damages that result from emitting 1 ton of greenhouse gases into the atmosphere. By putting effects of climate change into economic terms, this can help policymakers and other decision makers understand the economic impacts of decisions that would increase or decrease emissions. And there is a federal technical working group that analyzes the SCC. In 2021, the Colorado legislature passed several groundbreaking laws requiring that this figure be used in economic analyses. SB 246, HB 1266, HB 1238, SB 260, SB 264, and SB 272, unless I missed any. The current dollar amount used by the Colorado legislature for this figure is $68 per short ton of CO2 and $1,756 per short ton of methane emissions. This is based on that federal technical working group. Converting the 21.930 million metric tons CO2 equivalent of oil and gas emissions in Colorado to short tons, you get 24.174 million short tons of CO2 equivalent. If you multiply that times the number passed into Colorado law as the social cost of carbon per short ton, you'll find that number I quoted, $1.644 billion worth of climate change damages in 2019. That is the dollar amount of adverse impacts resulting from the oil and gas operations in Colorado in 2019, not including the burning of their product. The Oil and Gas Conservation Act, amended by SB 181, requires the Commission to regulate operators and hold them financially responsible for all adverse impacts resulting from their operations. So the adverse effect of climate impacts caused by each ton of emissions has a monetary figure. And I'm asking you, what are your plans to hold them responsible for the more than $1.5 billion of climate impacts caused by their emissions every year? Thank you for your time.
Thank you, Ms. Leithwood, for your comments. And you were right within 3 minutes, so very good. We appreciate that. Ms. Larson, who do we have next?
Next up, we have Shayna Oliver, and we will bring Ms. Oliver in.
Hello.
Good morning, Ms. Oliver. We can see and hear you.
All right, thank you. Thank you for making these public comments available. My name is Shayna Oliver. I am a resident of the Northeast Denver area, and I am also a field organizer with Moms Clean Air Force and Eco Madre's Colorado chapter, as well as being a parent leader of American Indian Academy of Denver, supporting Native and Indigenous students, as well as being a community member, and also being disproportionately impacted as a tribal affiliate of the Navajo Nation and being descendant of the genocide known as the Long Walk of the Navajo. And we are sitting on the ancestral lands of over 48 tribes, and the ancestral lands are not, we have not been given that right to be a part of these decision processes. So I would consider this process to be illegal on the terms of not having Indigenous input on your decision making. We have the right to be a part of these processes as Indigenous people, and to actually address the problems with climate action. And there's a lack of acknowledgement of climate change crisis in your department, and as well as your negligence to actually protect environmental, to actually protect environment and public health, and to actually mitigate and address these problems would be stop issuing permits on resources that are not rightfully yours. And these resources were stolen through genocide. And you guys need to acknowledge that these lands were stolen, and the resources are not for you to sell off our future generations' sustainable living and their environment and public health for their future. So you're actually stripping away and robbing our future generations' resources and their right to a safe environment and public health. And And in order to do that, you need to stop issuing permits, because these are not your resources to be given out in the first place. And tribes that are no longer on these lands have a right to speak up about the ecological damage to our lands and how that is impacting our children's future. So the right thing would be to do your job and protect our environment and our public health and move on forward without relying on fossil fuels. There is technology that can steer us away from this type of genocide. So thank you.
Thank you, Ms. Oliver, for taking time to present to us today. Ms. Larson, who do we have next?
Next up, we have Ilse Gold, and Ms. Gold will be participating on her telephone. So we have allowed her to speak. So Ms. Gold, if you'd like to unmute your phone, you should be able to participate.
And I see we have a phone with a phone number ending 98 that is with us. Perhaps that's Ms.
Yes.
Gold.
Ms. Gold, I believe it's #6 to unmute.
Might be *6.
Thank you, Commissioner. *6. Mr. Chair, perhaps she's having some connectivity issues. We can certainly come back to Ms. Gold, and we can try emailing her while we hear from other members of the public and get her to speak in just a bit, if that's all right.
That's fine, and you might try texting her phone number. That is her phone number from the sign-up list, and she's from Hesperus, Colorado, which is near from where I'm from, and I happen to know that's likely a cell phone number, so give it a shot.
All right, we will try it.
Do we have Jerry Shepard?
Yes, we sure do. So we'll bring Ms. Shepard in and give us a moment.
Good morning.
Good morning, Ms. Shepard. We can see you and we can hear you.
Thank you very much for the opportunity to address this body. My name is Jerry Shepard. I live in Greeley, Colorado. I am involved in various local political things, but mostly I'm here as a concerned citizen, a taxpayer, member of the community, and obviously there are some concerns that were noted by Ms. Leithwood, Ms. Oliver, and I joined in those concerns. I remember hearing a report last summer that Denver, Colorado had the worst air quality in the world. That should be troubling to this body, and this should be troubling to all of us in the community. And I am hoping that we find the political will to A, clean up the air, B, to actually have some accountability to the oil and gas industry. Every time I turn around, it seems like there's a leak somewhere. You know, you hear what's going on in Santa Barbara, and it's pretty horrifying what's going on there. And you see the photographs, and of course the, the danger to the sea life and the animals, and and part of it is this: oil and gas has been given carte blanche to, in essence, trash our planet with no accountability. And I don't know about you, but when I was a little girl, if I made a mess, guess what my mom told me I had to do? I had to clean it up. Somewhere along the way, oil and gas failed to get that message from their parents, and we as a country have failed to hold them accountable. This board exists for accountability. This board exists by statute to protect our communities, and I encourage the board to act in that capacity. We've had 4,408 wells approved in the last 3 years, and with all due respect, it kind of flies in the face of the statutory duty when it seems like our air quality keeps getting worse And I'm hoping we can find a way to move from this very dangerous form of energy. And I would hope that we would have a relationship to oil and gas other than that of drug addict and pusher. Thank you very much for the opportunity to address you. I hope you all consider this. I hope it's just a futile exercise that we community members go through that get ignored. Thank you very much again.
Thank you, Ms. Shepherd. Ms. Larson, who do we have next?
Forgive me, Mr. Chair. I was on the phone with Ms. Gold and we are diagnosing why we can't hear her. But while we're doing that, let me bring in Ms. Morrow and we will get her up and running. Oh, well, so it appears Ms. Morrow has declined to be elevated to be a panelist. Ms. Morrow, if you do wish to provide public comment, just raise your hand. I don't want to promote you again. If you don't want to provide public comment, that's fine. Oh, here we go. Looks like Ms. Morrow does wish to come back in.
Hello, can you hear me?
Yes, we can hear you and we can see you.
Awesome. I hit attendee instead of panelist because it just says panellee or attendee. So that was a little confusing, but I wanted to thank you for the opportunity to speak today. My comment is short and simple. I know that all of you are well educated on all of the things that are happening with oil and gas. I just am here to express as a Colorado taxpayer my wishes for this committee. First, I'd like to express the delays in financial assurances and rulemaking are unacceptable. I voted for Senate Bill 181 that was signed into law like 2.5 years ago. And it's going to be 3 years old before any of the financial assurances rulemakings take effect. So I thought by now we would have made some actual progress in preserving our water and air resources and protecting the health of Colorado people. It really blows my mind that since the law was passed, we've actually gotten worse. There's been over 3,000 wells that have been permitted without the necessary financial assurances, and that's just unacceptable and crazy for me to try to understand. I'm also alarmed by how much oil and gas has cost the state of Colorado. Whitting Petroleum, Extraction, and PetroShare have all filed for bankruptcy, costing Colorado residents millions of dollars. We just can't trust the gas market's boom and bust price swings anymore. We really need to transition to renewable energy, both for the taxpayers' pocketbooks and our health and well-being. As a Colorado taxpayer, I believe that I should be and the people should be who the Cogcc protects by pausing all permits and asset transfers until new rules are in full effect. And that's all I have for today. Thank you for your time.
Thank you, Ms. Morrow, for participating with us and providing your perspective. Do we have Ms. Gold accessible to speak? And if not, I believe that the next speaker perhaps would be Andrew Forks Goodmanson.
Yes, Mr. Chair, I'm speaking with Ms. Gold now. So let's go back and bring Mr. Goodmanson in, and then perhaps Ms. Gold will be able to speak after Mr. Goodmanson.
Okay.
Sorry, there's a few buttons you got to click to get in as a panelist. Good morning. Thank you for the opportunity to provide public comment this morning. My name is Andrew Forkus Goodmanson. I'm the Deputy Director of Logic, the League of Oil and Gas Impacted Coloradans. And I'm here today with hopefully a very, very short public comment this morning. and that is to join in with the folks that are asking you to please pause the transfer of oil and gas wells, permits, assets, et cetera, at all until the effective date of the financial assurance rules. Though the delay in this rulemaking was likely justified by a whole lot of extenuating circumstances, not the least of which being the KP Kaufman enforcement proceeding, which I know is taking a lot of staff time and effort, along with commission time and effort. The fact of the matter is that this rulemaking has taken quite a long time, and we're still quite a long time from the effective date of these rules. And this rulemaking was started because we know that there's a problem with the financial assurances structure in this state. And I believe that allowing that problem to get worse just because the rulemaking is ongoing is not the best practice this commission could be following. So with that, I would just strongly urge you to pause the transfer of permits and assets until the effective date of the financial assurances rulemaking. And thank you for your consideration.
Thank you, Mr. Forks Goodmanson, for being with us and presenting today. Ms. Larson, who do we have next?
So next up, we'll hear from Alexis Schwartz. Just as an update to the commissioners, I spoke with Ms. Gold, and she's actually going to email in her comments. They were targeted towards the financial assurance rulemaking. So she will send those in to me, and then I will make sure to get them to the commissioners, and we'll also add them to the financial assurance rulemaking docket.
Thank you, Ms. Larson, for accommodating Ms. Gold that way. We appreciate it.
Certainly.
Schwartz, I think we see you, and if you want to say something, we see if we can hear you.
Sure. Good morning, commissioners. Thank you for the opportunity to speak this morning. My name is Alexis Schwartz. I'm speaking today as a concerned Coloradan and a resident of Denver. I urge you to prevent the transfer of assets prior to the effective date of the Cogcc enacting and implementing much needed updates to the state's financial assurance regulations for the oil and gas industry. Allowing transfers to continue under the status quo without adequate assurances that operators are able to shoulder their responsibilities to protect the public imposes financial and safety risks on Colorado. This commission has the authority to find that the transfer of permits cannot occur until after the financial assurances rulemaking is complete, because those permits are not currently in compliance with the requirement that every operator must provide assurance that it's capable of meeting every obligation imposed by all the commission's rules. Thank you for this consideration of your request.
Thank you, Ms. Schwartz, for presenting to us. Ms. Larson, does that cover the folks that have signed up, with the exception of Ms. Gold, who will now have a written comment?
Yes, it does.
Okay, very good. With that, we will continue with our agenda. We do have a report from the director, which is not mandatory, and I'm not sure if Director Murphy has a report for us, but I will call upon her to see.
Thank you, Chair. I have a pretty brief one. I think I'm going to kind of start with enforcement, and just wanted to flag that based on this commission's direction kind of throughout the summer and expressing concerns about default proceedings, or I've asked enforcement staff to prioritize work in that space, and that's led to a number of the matters before you today, with the idea that it's best to get these resolved and moved forward quickly. So that's some context. And then the other piece of my update is very operational, in that we are very excited to announce that Sabrina Trask is taking over the management responsibilities for our permitters and our OGLAs, which are our teams responsible for reviewing APDs and 2As and how that process intersects with the hearings and the rest of the organization. So she's certainly signed up for quite a task, and we're very excited for her leadership in that space. And then we are also in the process of interviews for a new technical services manager, but I'm just really excited about the organizational changes and improvements that we're making to meet the expectations of the sweeping rule changes that you all adopted in November in response to Senate Bill 19-181, and that we've been diligently implementing since January 15th of this year, those have been important changes, and we're very proud of the work going into them. So that's the sum total of my update, and look forward to supporting you all through the rest of today's hearing.
Thank you, Director Murphy. Appreciate that. Extend our thanks to Ms. Trask for stepping up. I think she's a great person for that job, and I think that's good for the commission. Okay, we will continue down our calendar. We are at the hearings section of our calendar, and I believe we will now hear briefly from staff on 5 enforcement defaults. Ms. Larson, are we looking to Mr. Farron to present on this?
Actually, Assistant Attorney General Schwartz will be presenting on this, 3 of these matters, in fact.
Very good. AAG Schultz.
Morning, commissioners. Nice to see you again. Try to be as brief as possible. See if I can share my screen. It's the most anxiety-inducing part of the whole presentation. Can everyone see that okay?
We can.
Okay. Good morning again. My name is Scott Schultz. I'm an Assistant Attorney General representing Cogcc enforcement staff in this matter involving Smith Energy Corporation. In this hearing, I'm requesting that the Commission enter order finding violation 757 against Smith Energy Corporation. Smith Energy Corporation is the operator of record of 37 wells located in Adams, Arapahoe, Elbert, Morgan, and Weld counties. 35 of Smith Energy Corporation's 37 wells meet the regulatory definition of inactive wells, meaning that the wells are shut-in wells from which no production has been sold for a period of 12 consecutive months or have been temporarily abandoned for 6 consecutive months. Let me just add now, I'm open to any questions that the Commission may have at any time, but obviously get full till the end as well. A letter from a lawyer representing Smith Energy Corporation dated May 24th, 2019, and addressed to the director of the COGCC, stated among many things, quote, with no income and no prospect of income in the future, Smith Energy Corporation is forced to terminate and dissolve. For this reason, the corporation is officially turning in all of the wells operated and owned by Smith Energy Corporation to the Orphan Well Program. On June 6th, 2019, COGCC staff conducted an audit of Smith Energy Corporation's wells and the amount of financial assurance it had with the Commission, and identified 35 inactive wells that had a total measured depth equal to or greater than 3,000 feet. On June 7th, 2019, an NOAV was issued to Smith Energy Corporation, alleging that pursuant to Rule 707A, a balance of $640,000 of excess inactive financial assurance was required due to the 35 inactive wells. Rule 707A requires $20,000 in additional financial assurance for each of Smith Energy Corporation's excess inactive wells greater than 3,000 feet in total measured depth. So 20,000 times 35 inactive wells greater than 3,000 feet equals $700,000 that Smith Energy was required to have in financial assurance with the Commission. Smith Energy has a blanket plugging bond of $60,000, $640,000 short of the required $700,000. Pursuant to Rule 707A, the excess financial assurance requirements for inactive wells shall be modified or waived if the Commission approves a plan submitted by the operator for reducing such additional financial assurance requirement, for returning wells to production in a timely manner, or for plugging and abandoning such wells on an acceptable schedule. Smith Energy Corporation provided no such a plan to COGC staff. On September 20th, 2019, a notice and application for hearing was issued to Smith Energy Corporation involving the NOAV alleging a violation of Rule 707A. But then on November 14th, 2019, Smith Energy Corporation filed for Chapter 7 bankruptcy in the United States Bankruptcy Court for the District of Colorado. Just a little bankruptcy refresher. Chapter 11 of the Bankruptcy Code provides for an insolvent business to reorganize under court supervision while continuing its normal operations and restructuring its debt. While Chapter 7 of the Bankruptcy Code allows for a bankruptcy trustee to collect and liquidate a debtor's property to satisfy creditors. Smith Energy Corporation's Chapter 7 bankruptcy has not been discharged and is still currently pending and subject to the jurisdiction of the Bankruptcy Court. On August 6, 2021, a stipulation for relief from the Bankruptcy Court's state provisions was agreed upon and filed in the Bankruptcy Court proceedings. The stipulation was agreed to by Smith Energy Corporation's bankruptcy trustee and one of my counterparts at the Attorney General's office, our bankruptcy counsel, Robert Paget. So you can see how long this matter has taken since Smith Energy filed for Chapter 7 bankruptcy back in November of 2019. And I won't bore you with the details of the bankruptcy court matters, how I thought we had an agreement to a stipulated order finding violation and that fell apart. But it would have even taken longer if it were not for the stipulation for relief from stay agreed upon 2 months ago. Turning your attention back to this proposed order finding violation, enforcement staff is requesting that the commission find Smith Energy Corporation in violation of Rule 707A for the previously stated reasons. This slide seeks to provide the commission with more background information regarding Smith Energy Corporation's violation of Rule 707A. Again, Smith Energy Corporation currently only has a cash bond of $60,000 with the Cogcc. Enforcement staff is requesting that the commission order Smith Energy Corporation to return to compliance with the act and rules. Enforcement staff is requesting that the commission order Smith Energy Corporation to pay a penalty of $50,550 for a 161-day violation of Rule 707A. The Rule 707A violation started when Cogcc staff discovered that Smith Energy had 35 inactive wells and a balance of $640,000 for excess inactive financial assurance was required, and ended when Smith Energy filed for Chapter 7 bankruptcy. The duration matrix was also utilized in calculating this penalty. Enforcement staff is requesting that the commission order and include requirements that if Smith Energy Corporation does not return to compliance or pay the penalty imposed within 35 days of transmittal of this order, that the director shall revoke Smith Energy Corporation's authorization to conduct oil and gas operations in Colorado and foreclose on the $60,000 in financial assurance. Enforcement staff is requesting that the commission order include provisions that allow for the director to, 1, declare Smith Energy Corporation's wells orphaned, and 2, investigate, prevent, monitor, or mitigate adverse environmental impacts at wells formerly operated by Smith Energy Corporation. There are several other provisions included in the order finding violation that is in your portfolio, but instead of me reading or summarizing them to you all, I'm happy to simply take questions that you may have at this time. One last thing before I open up to questions is in reviewing this last night, I did see a small error. It is on page 4 of the order, paragraph 4, and currently the OFV says 30 days, within 30 days of transmittal. It should be consistent with the other OFVs and with the other time laid out in the order, and it should be 35 days instead. Again, that's page 4, paragraph 4. My apologies for that error. Does the commission have any questions regarding Smith Energy Corporation and this order finding violation?
AG Schultz, is the 35 days contained within our rules following entry of an order by the commission to allow them time to come into compliance?
Yes.
Okay. And Smith Energy has not responded to the NOAV, et cetera, at this point, and we do not have a representative from Smith today. Is that right?
Correct. The complication is, again, that Smith Energy Corporation is still in Chapter 7 bankruptcy. So those proceedings continue. I have been in contact with the trustee, and you can see some of the lawyer language and edits that they made to the order finding violation. But again, we had the stipulation that we entered into with the bankruptcy court with the trustee that allows for this proceeding today, kind of dovetailing with the bankruptcy court proceedings.
Great, thank you. Do commissioners have questions? Okay, I'm seeing no one unmute themselves. So at this point, commissioners, I believe that if we do not have any objections to staff's proposed order finding violation, then we should seek a motion to approve the proposed order. If any commissioner desires to tweak the order, we can do that in the motion. And I believe that we've been requested to tweak page 4, paragraph 4, moving that number 30 to 35 days. Commissioner Nanjappa.
I move to approve the order with the change from 30 days to 35 days in the paragraph as noted, and to include all of the relief that staff has requested.
Okay, we have a motion. Do we have a second?
Second.
We have 2 seconds. Do we have any further discussion on the motion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. A.J. Schultz, you're up again.
Thank you, Commissioner Robbins. Let's see. Okay, can you see this this new slide presentation?
We can.
Excellent. In this hearing, I'm requesting that the commission enter order finding violation 768 against the operator Larry Javernick. Larry Javernick is the operator of record of a domestic well located in Fremont County. However, he is not the service owner where the domestic well is located. As a result of a service owner complaint, staff conducted an inspection on May 31st, 2018 and observed the venting of gas from a disconnected flow line next to the domestic well. On June 27th and 28th, 2018, staff oversaw the plugging of the well and spent approximately $13,000 to have the necessary work performed. On November 11th, 2019, staff issued the operator, Larry Javernick, an NOAV for violations of Rule 605D and 912B. In the inspection report dated May 31st, 2018, it was stated by staff that Mr. Larry Javernick passed away on June 3rd, 2016. Not as stated in this slide, July, and also in the OFE states July. I don't think it's necessary to make those edits, and I apologize for that. I think it was fat fingers between June and July, but staff has reason to believe that Mr. Larry Javernick passed away on June 3rd, 2016. Enforcement staff is requesting that the commission find the operator, Larry Javernick, in violation of Rule 605D for failure to maintain all valves, pipes, and fittings securely fastened and inspected at regular intervals and in good mechanical condition. Enforcement staff is requesting that the commission find the operator, Larry Javernick, in violation of 912B for venting gas. Enforcement staff is requesting that the commission order the operator, Larry Javernick, to return to compliance with the Act and rules. Enforcement staff is requesting that the commission order the operator, Larry Javernick, to pay a penalty of $319,485,000 for 41 41-day violations of Rule 605D and 912B, and to pay for the work performed by COGCC contractors in plugging the well, again, approximately $13,000. You can see the breakdown of the penalty calculation here. Again, penalty duration matrix was applied. Maybe not the best use of a slide ever in a presentation, but what I'm really saying is that the operator, Larry Javernick, has a $5,000 cash bond for the well. Enforcement staff is requesting that the commission order include requirements that if the operator, Larry Javernick, does not return to compliance or pay the penalty imposed within 35 days of transmittal of this order, that the director shall revoke Larry Javernick's authorization to conduct oil and gas operations in Colorado and foreclose on the $5,000 of financial assurance. Enforcement staff is requesting that the commission order include provisions that allow for the director to, 1, declare Larry Javernick's well orphaned, and 2, investigate, prevent, monitor, or mitigate adverse environmental impacts at the well formerly operated by Larry Javernick. I will add that there is some work for the orphan well team to do, some reclamation work still at this well. So putting this order will allow this well to be put on the orphan well list and for that work to occur. And with that, I'm open to any questions that the commission may have.
Commissioners, does anyone have questions on this matter? Commissioner McGowan?
Thank you, Mr. Chair. I'm sorry to sound dense, but I assume that this is just a formality. If we think Mr. Javernick has passed away, it's hard for him to do anything.
Right.
Okay, all right, just checking it.
And the well hasn't been transferred to anyone. He still is the operator of record. This is the perfunctory measures that we have to go through to claim the financial assurance, put the well on the orphan well list, and revoke their ability to operate Colorado.
Any further questions from commissioners? Seeing none, do we have a motion to approve the order finding violation?
So moved.
Second.
Commissioner Gonzalez so moved and Commissioner McGowan seconded. Do we have further discussion? Seeing none, all those in favor signify by saying aye.
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 Any opposed? Motion carries. I believe we now have the Alanko Energy Services matter.
Correct. Thank you, Director. In this hearing, I'm requesting that the Commission enter order finding violation 767 against the operator Alanko Energy Services, Inc. Alanko Energy Services Incorporated, which I'll refer to as Alanko, is the operator of the Deer Creek SWD-1 facility in Mesa County. As this timeline indicates, this well was unfortunately spud before receiving the necessary approval for an underground injection permit by staff. On June 13th, 2011, after the well was spud, staff concluded that the proposed disposal well could result in significant adverse impacts to the environment and human health, given the depth and location and local geology that could adversely impact tributaries to the Gunnison River. This injection well has had its fair share of drama. Alanko stated to staff that it was contemplating alternatives to an injection well once staff rejected their permit application, such as converting the well to be a geothermal well or a water supply well. None of those ideas ended up panning out. This well has also changed ownership a few times and it's been the subject of landlord-tenant disputes. And that's part of the reason why we're here today. This well is somewhat unique. This proposed injection well, it is located in the Goodwin Solid Waste Disposal Facility, Mesa County issued a certificate of designation for the facility that included an engineering design and operation plan approved by the Hazardous Materials and Waste Management Division of CDPHE. This provides just a timeline of when the NOAVs were issued. You can see that we have provided notice regarding these NOAVs. There's 4 separate NOAVs that are involved in this order finding violation. Here's a picture of the well. Notice said that a picture is worth 1,000 words. This one might be a little less than that, but I'll let you be the judge of that. This is a picture of the essentially failed injection well. Here's a little more background on the notice provided to Alanko. You see they've been provided ample notice of this matter. Enforcement staff is requesting that the commission find Alanko in violation of numerous rule requirements. I won't bore you with the details of them. I am open to any questions, but you can see staff is asking that the commission find Alanko in violation of all of these rule requirements. Enforcement staff is requesting that the commission order the operator Alanko to return to compliance with the act and rules. Enforcement staff is requesting that the commission order the operator Alanko to pay a penalty of $353,680,000 for their violations. You can see the breakdown of the penalty calculations here. Again, the duration matrix was applied. You can see that most of these violations are ongoing, ending at today's date. Again, maybe not the best use of a slide here, but Alanko has the $10,000 cash bond for this well. Not to sound like a broken record here, but enforcement staff is requesting that the commission order include requirements that if the operator Alanko does not return to compliance or pay the penalty imposed within 35 days of transmittal of this order, that the director shall revoke Alanko's authorization to conduct oil and gas operations in Colorado and foreclose on the $10,000 in financial assurance. Lastly, enforcement staff is requesting that the commission order include provisions that allow for the director to, again, declare Alanko as well orphaned and investigate, prevent, monitor, and mitigate adverse environmental impacts at the well operated by Alanko. With that, I'm open to any questions that the commission may have.
Thank you, AAG Schultz. Are there questions from commissioners on this matter? We're starting to get this down. No questions. Do we have a motion to approve the proposed order?
So moved.
Do we have a second? We have a motion from Commissioner McGowan and a second from Commissioner Nanjapa. Any further discussion? Seeing none, all those in favor signify by saying aye. Aye. Any opposed? Motion carries. We have 2 more to go. PCR operating, and it looks like Ms. Rosenberg is going to present.
Are you able to see my screen here?
We are.
Okay, thank you. Good morning, commissioners. And at the outset, I just want to say quickly that I'm having some significant work done on my house, and it hasn't caused any issues this morning, but I may have to, for a moment, mute myself and shut out my video if things go awry here for a moment. Good morning. I'm here to present docket number 2011000264, proposed order finding violation 769 for PCR. I want to provide a little background. This matter has a long history, and it goes back as far as 2009, and I will very briefly give you a very high-level overview of how we got here. And we are talking about the Adena field, which is a very large old field. It's a conventional oil pool field, and it is mostly shut in. The issue we have is that there have been large compliance issues with this field for many years, and we've gotten to the point where we just need the commission to step in and assist us here. Relevant here, in 2009, the commission entered Order 1-145, and for purposes of what you need to know is just Club Zuba Oil and Gas was the operator of record for the Adena field, and several rule requirements were relaxed for the operator. In 2011, Black Raven Energy acquired the well subject, Order 1-145. And when Black Raven acquired the field, again, just to give you a little context, there were 7 producing wells and 5 active injection wells. A large majority of them, about 124, were shut in or temporarily abandoned. And at the time, Black Raven believed it would be economically wise to reactivate the shut-in or temporarily abandoned wells. So with that in mind, in 2014, the commission entered Order 186, and this gave Black Raven a timeline between 2014 to 2018 to sort of assess the field and see what wells were worthy of being returned to commercial production. And in particular, the mechanical integrity testing requirements of Rule 326B were relaxed because it gave Black Raven the opportunity to manage and develop the field while determining if individual inactive wells were capable of commercial production. And then in 2015 and in 2016, Black Raven sought 2 more commission orders to relax the requirements even further. And so in essence, 40 wells that were supposed to be assessed were not assessed during those 2 years. And then in the very end of 2016, the commission entered Order 1201. And this clarified that PCR, as the successor in interest to Black Raven, is now the operator of Adena Field, and that Order 186 now applies to PCR. In 2017 and 2018, PCR neither complied with Order 186, nor did it seek to modify the requirements of Order 186. Pardon me, am I still there? Something unusual just happened on my screen. Okay, sorry about that. And by its own terms, Order 1-186 expired at the end of 2018. Between 2019 and 2021, PCR offered staff several paths for compliance regarding getting up to date, particularly on their mechanical integrity tests that were significantly behind. And in addition, PCR discussed transferring the wells to an outside company for carbon sequestration, but did not follow through with those plans. So over the course of a couple of years, there have been discussions with staff, but PCR didn't ever follow through on their proposed paths forward. Around the same time, 2019 to 2020, staff performed an audit of PCR's records. And as a result of that audit, staff issued 4 NOAVs. 3 of them dealt with PCR's failure to file its monthly reports of operations, and 1 dealt with PCR's failure to perform required mechanical integrity tests for 33 wells. And in both instances, PCR is actually negligent with regard to 64 well MITs that are overdue. And they have also not filed monthly reports of operations for many other subsequent months, but these are the 4 NOAVs that have been issued. And then just a little procedural background for how we got here. PCR did not file answers for the Rule 309, the monthly report of operations NOAVs. PCR did respond with an email with one of its proposed MIT schedule plans in response to the 326 NOAV. But PCR has not responded to any of the emails or outreach that staff has done regarding the enforcement proceedings specifically. PCR has not filed any pleadings in the matter. The matter was noticed for hearing in February and properly published, sent to via certified mail to the address on file, email to the designated agent on file with the commission, and PCR did not respond. So to date, PCR has failed to participate in the contested pre-hearing process. And as recent as last night, I sent an email to the designated agent, and they don't appear to have participated today. Now, there isn't a heavy penalty associated with this. In this matter, staff is proposing a $4,390 penalty for the 309 violation. And in this instance, there were 3 separate violations for the monthly reports of operations. Staff consolidated it into one violation for purposes of penalty assessment. In addition, because of the dates of the required MITs, it was questionable whether staff could assess a penalty for the missing MITs. So staff didn't assess penalties for those, but did allege the violation of that rule. Consistent with what Mr. Schultz requested, staff just, as the order is set out in the order, staff has requested that the commission declare PCR's 151 wells orphaned, claim all of its product, revoke PCR's authorization to conduct oil and gas operations, and then foreclose on PCR's financial assurance, which is $535,000, and it's all in cash surety instruments. And because of PCR's failure to participate in this proceeding, and for the years of sort of lack of compliance and then stopping the communication with the commission about compliance, we seek that the commission approve our recommended order finding violation. In addition, consistent with what Mr. Schultz requested, in order to comport with the requirements of the Administrative Procedures Act judicial review provision, I also make 2 clerical changes. Paragraph 2 on page 4 of the proposed order, and then paragraph 4 on page 5, I ask that those references to 30 days be changed to 35 days. And with that, if you have any questions, I'm happy to take them.
Thank you very much. Before we take commissioner questions, I just want to confirm that we do not have any representatives from PCR in the hearing. If there are representatives from PCR, please raise your hand and we will acknowledge you. With that out of the way, do any commissioners have questions of Ms. Rosenberg? Seeing no questions, do we have a motion to approve the proposed order finding violation?
So moved.
Second.
We have a motion from Commissioner Messner, a second from Commissioner Nanjapa. Do we have further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. Thank you, Ms. Rosenberg, for your presentation. And I believe the final default enforcement matter is with Hearings Officer Kirschner. Hearings Manager Amaro, oh, there he is.
Okay. Sorry about that, everybody. Just had to get elevated to panelist. I'm going to share my screen.
Very good.
All right, and I'm hopeful that we can all see the presentation.
We can.
Great. Once again, commissioners, my name is Steve Kirschner. I'm one of the enforcement officers here with commission staff. Today I'm going to present a stipulated order finding violation between the director and Sandra K. Woodard, operator number 10342. This is order number 1V765. I'll note at the outset here that while this is largely similar to other cases you've heard today, it's different in one important distinction. Staff did reach an agreement with Ms. Woodard to affect the order that you have in your portfolio today. So this is slightly different from the default, but we're essentially going to the same place. So with that, we'll get started. Just some background, Ms. Woodard operates 3 wells in Rio Blanco County, just outside Rangeley. Those 3 wells are listed here on the slide. Staff inspected these wells from 2019 through 2021, and As is common, Ms. Woodard filed for Chapter 7 bankruptcy in 2021. As you heard earlier from Mr. Schultz, Chapter 7 involves liquidation of assets to pay debts by a trustee. Staff has had contact with the trustee in this matter, and staff has had contact with Ms. Woodard's personal attorney. I can represent that the bankruptcy proceedings did conclude earlier this year in August. Just some brief detail on the violations themselves. At the Stagner 2 well, staff observed gas venting from the wellhead over the course of several inspections. The venting condition was ultimately corrected by staff after expending some money from the Orphan Well Program Fund to pay a contractor to go out there and repair the well. Similar situation at the Stagner 6, staff also observed gas venting from that wellhead. In addition, we observed oil-stained soil at the wellhead and in some spots around the facility. The gas venting condition was corrected by contractors paid by the Orphan Well Program. The oil-stained soil conditions remain at the site. And similar situation at the other well, we also observed gas venting from the wellhead there. That situation was corrected by contractors paid from the Orphan Well Program. We also observed some oil-stained soil at the wellhead and at the flow line, and those conditions do remain today, and hopefully will be corrected once we're able to get in there and reclaim those locations. Just a brief note on the bankruptcy proceedings. Ms. Woodard did file for bankruptcy earlier this year, and that discharge order was entered in August by the U.S. Bankruptcy Court for the District of Colorado. Just to run through the enforcement proceedings here, on August 7th, 2020, staff issued the 3 NOAVs to issue here to Ms. Woodard. Staff noticed this matter in August of 2021 and served the notice on Ms. Woodard in September. Notice was published in accordance with the rules in the Act in September in both Denver and Rio Blanco counties. Staff had some discussions with Ms. Woodard, and on September 22nd, Ms. Woodard consented to the filing of a motion by staff to remove this the matter directly to the commission, so you could hear it today. And on September 27th, 2021, Ms. Woodard and the director through staff executed the stipulated order finding violation that's been placed in your portfolio. Staff then filed the OFV and moved the hearing officer to remove this directly to the commission. And that motion was granted on October 1st. To go over the penalty calculation, we obviously have the violations of 912B and 907E is laid out here. Those penalty amounts were calculated using the duration matrix, which you've seen before. The penalty amounts totals more than $1.5 million. It also includes the payment for the contract work done to correct the venting conditions observed at the 3 wells. At the direction of the director, staff agreed to suspend the assessed penalty if Ms. Woodard agrees to suspend all oil and gas operations in the state of Colorado. In accordance with this, if you approve the order, the director shall immediately or as soon as practicable revoke Ms. Woodard's authorization to operate in the state of Colorado and foreclose the financial assurance, which in this case is a $30,000 cash bond. The director is authorized to declare Ms. Woodard as well as orphaned and to use the foreclosed financial assurance as well as Orphan Well Program funds to reclaim the locations and to plug and abandon the wells. The OFV also includes a clause stating that if Ms. Woodard ever seeks to conduct oil and gas operations in the future in Colorado, she must pay the penalty in full. And then prior to conducting such operations, she must come back before the commission at a hearing. The commission then has the option of whether to grant that application, to require additional financial insurance, or to deny the application. So to sum up, if she wishes to conduct oil and gas operations in the future in Colorado, she must both pay the entire penalty and come before the commission to seek approval to do so. Staff therefore asks that the commission approve the stipulated OFV that's been placed in your portfolio and executed by the director and Ms. Woodard. And with that, I'm happy to take any questions you might have about this matter.
Thank you, Mr. Kirschner. We do not have a representative on behalf of Ms. Woodward at this point, right?
I don't know. I've provided the link in the agenda to Ms. Woodard. I don't know if she's present today.
Okay, well, if she is present and she desires to comment, we would be happy to hear from her. She can raise her hand and we can bring her to the panel. With that, do any commissioners have questions with regard to this matter? Commissioner Nanjapa.
Thank you, Mr. Chair. It's a question, I suppose, more for staff. I was just curious. I noted that it was in 2019 that the gas that was venting was first noted, but it was quite a while, almost 2 years later, I believe, before it was actually action was taken after there wasn't a response from the operator. Obviously understand that last year with COVID, there may have been some limitations, but I just wanted to understand better why we potentially had gas venting for 2 years.
I don't know that I'm going to have a satisfactory answer, but from what I understand, the gas venting wasn't observed as a particularly serious venting event by the inspector. They also gave the operator several opportunities throughout that year to correct the situation, and it wasn't corrected. Ultimately, this came to our attention through the trustee, at least enforcement staff's attention through the trustee earlier this year, and that's why it was corrected when it was. I think there's definitely we could definitely take a look at why this took so long to correct, but enforcement staff wasn't involved in that decision.
Okay, thank you, I appreciate that. And I guess I would just comment that especially when there's an issue like that, whether spill or vent, I think we need to take much quicker action as a commission if the operator is not responsive.
Thank you, Commissioner Nanjapa. Further questions? Seeing none, do we have a motion to approve the stipulated order finding violation?
So moved. Second.
Okay. I note that Ms. Woodward is in the meeting, but I also note that she has not raised her hand. It looks like perhaps we've elevated her to panelist. Before we take action on the motion that's pending, if Ms. Woodward desires to say anything, now would be her opportunity. She would need to unmute herself. I would note for the record that in our portfolio, the stipulated order finding violation is signed off by Ms. Woodard. So with that, and seeing that she's not attempting to further comment, which is perfectly fine, would look for a vote. All those in favor of the motion signify by saying aye.
Aye.
Aye. Any opposed? Motion carries. Okay, I believe that covers the default docket. Want to thank staff for acting on the direction from commission to move forward with these cases that are basically orphaned, but they're not found their way through our system. I really appreciate trying to clear that backlog. I see Director Murphy is with us. Thank you, Director Murphy, for your team's efforts on this. Do you have anything further?
Just wanted to echo my thanks to staff for their hard work and kind of reorganization of priorities. There will probably be a few more of these matters coming through. We've tried to organize them on a couple of days and some of the notices didn't work out. So this probably isn't the last, but we are trying to move through that this fall. And, you know, complementary to this, continuing to work on improving our enforcement process in line with commission direction and also understanding how we can motivate compliance as is our priority in most cases. So thank you very much.
Thank you, Director Murphy. Commissioner McGowan might have a thought or comment.
Thank you, Mr. Chair. And I was trying to decide whether to wait till the end for commissioner comments, but this might be a more appropriate time to ask a few questions that I have about how our enforcement process works for some of these. How often do we audit operator contact information to ensure that someone is still alive or is the primary operator and responsible? Is one of my questions. How often do we compare an operator's portfolio with their financial assurance requirements? So I get that they're supposed to be responsible. So if a status changes with their wells, their financial assurance, they're supposed to update their financial assurance. But I'm curious to know if we kind of do a trust but verify or a random audit sometimes. And then I guess I'm a little confused as to how often financial assurance is submitted. And is it only submitted once before an operator commences drilling a well? Or are they required to update their financial assurance with us each year annually to let us know that they are up to date on their financial assurance requirements? When I was just kind of trying to peek into Cogcc and look at financial assurance, and some of the dates seem old, but that was maybe because that's when they started or commenced their operations, and that's when they had to submit their financial assurance. So it was unclear to me how we keep that updated or how we ensure that someone's financial assurance is up to date.
Director Murphy, do you want to try to answer now? Do you want to go gather with your team to get answers and report back? What's the best approach for these good questions?
I'd like to start with a high level response and recognizing that my knowledge is not perfect and see where that gets us. So in terms of auditing or contact information for an operator, Commissioner McGowan, all operators are required to file production reports monthly. And so kind of monthly, we do have an informal or a check-in to see if somebody is responsive for those wells and is maintaining that information for us. So I wouldn't say it's a formal determination of whether the designated agent is viable, but it's a question of whether somebody is being responsible and responsive for reporting information to us. And so again, I think that provides us eyes into whether we have a human being on the other end. But it's not a formalized process where we're looking at their Form 1s, contacting that person to say, are you still the designated agent? So I wanted to be clear that I think that's an informal check-in, but I think it accomplishes your concern. And again, in response to the 2020 audit, we have really revamped our production reporting scrutiny so that we're reviewing those and auditing production reports monthly and getting warning letters out, and then if appropriate, NOAVs. And we've gotten great responsiveness from that change in process. In terms of evaluating operators' financial assurance compliance with existing rules, there is not a regulatory mechanism in the 700 series that prescribes an annual audit of an operator's financial assurance. That said, at a number of points along the way, staff does check for compliance. The ones that come to mind for me are permitting and then enforcement. I think those are the two places where we do systemically check compliance. And then our financial assurance lead, Ms. Lutz, does audit compliance with excess and active wells in particular, I think every year for operators, and that creates a slug of work. And operators also self-report in instances where circumstances have changed. So I think we do have a process, again, it's somewhat informal, and I think that's one place where the draft rules are creating a conversation among stakeholders. And I think that those were the kind of I gave a mixed answer to your last two questions.
Follow up, Ms. McGowan, Commissioner McGowan.
I guess I'll wait and see how we might be able to address this as we update our financial rulemaking. But I think that some of these issues fall on us when we're not paying attention to what's happening with an operator, and maybe there's a way for us to tighten that up in the future. So I'll look forward to the conversation.
Any further questions for the director? Okay, seeing none and seeing that we've been going at it for about 2 hours, I suggest we take a morning break. Let's return at 10:45. I'll give us about 10, 11 minutes, and we will see everybody then. Okay, welcome back, everybody. We will continue with the Colorado Oil and Gas Conservation Commission's agenda. Next on the agenda is the general consent agenda. We have 2 hearing officer recommendations under Rule 505. These have been reviewed by commissioners in our portfolio. Do any commissioner have any questions relevant to the 2 hearing officer recommendations? Seeing no questions, do we have a motion to approve the general consent agenda?
So moved.
Second.
All right, I have a motion from Commissioner Gonzalez and a second from Commissioner McGowan. Any further discussion? All those in favor signify by saying aye. Aye.
Aye.
Any opposed? The general consent agenda is approved. We now have before us our oil and gas development plan consent agenda. We have 2 dockets, docket number 21030017, Bayswater Exploration and Production. And then we will take up docket number 21050081. We have these on our consent agenda. I believe we're going to try to take it up like we did last time, which would first establish if there's any public comment. And let's take it one at a time. So Ms. Larson or Ms. Amaro, do we have any public comment for the Bayswater Exploration and Production matter?
Mr. Chair, we did not have anyone sign up for public comment for this OGDP.
Okay. With that, do we have a representative from Bayswater that would like to provide an overview of the proposal for us at this time?
We do have Mr.
Yes.
Struna. Forgive me, go ahead.
Good.
I'm sorry, yeah.
Good morning, Mr. Struna. Good to see you.
Good morning, good to see you. I'm Steve Struna, the president and CEO of Bayswater Exploration and Production. I have a short presentation that I'd like to run through and then set up for some questions. I have colleagues on the line that we could direct questions to should they be raised. Before I get started, I'd like to thank Chairman Robbins, Commissioners Gonzalez, McGowan, Messner, and Joppa for your time today. I'd also like to thank and recognize Director Murphy and her staff for their effort and continued collaboration with our team through this process. So with that, I'll jump into a presentation. I'm hoping I can share my screen here and maximize that. Okay, there we are. Thanks. So I'm gonna run through this at a very high level and then leave time at the end for some questions. Just kicking off a little bit, who Bayswater is. Private company, been around since 2004, headquartered here in Denver. We also have a field office in Eaton, Colorado. We're privately capitalized. We've been capitalized through a series of energy funds with direct institutional investors, predominantly blue chip college endowments and foundations, a very ESG sensitive investor base. We've had a continuous 1-rig drilling program running here in Wattenberg since June of 2017. We underestimated how long this permit process would take. So we had to lay our rig down temporarily here in July, but during that 4-year period, we drilled about 175 horizontal wells out here, all very similar to the ones contemplated in this application. We operate 205 wells. We have about 21,000 net acres and about 29, just under 30,000 BOEs a day. So we're a pretty substantial small player. Of that 21,000 acres that we do have, about 40% of it is undeveloped. So we still have a lot more to do on permitting and the OGDP side. And so we're optimistic what we learned in the template that we've built through this process will streamline things going forward. We're spent a lot of money out here. We've spent about $700 million in Weld County since 2017. In the past 4 quarters, we've employed just 550,000 man hours in the field, and that's a diverse, predominantly Hispanic workforce. So that's a quick background on Bayswater, focusing in on our development area and our plan. The dashed red outline here in the center, that is our spacing unit, 1 mile by 2 miles, 1,280 acre mineral development. The green outline here is our proposed surface location. This area is located between the towns of Galt and Severance out in northeastern Colorado. It's mixed use, some key surface features here. One, it's inside of a minority population, disproportionately impacted community. That's the blue outline. There's rural and industrial use. There's a large waste management landfill here, some sheep farming operations to the south and east, some dairy operations due south. There's a 1 square mile subdevelopment there, a subdivision. It's the Belmont Farm subdivision. That's been around since for about 20 years. It's currently actively being developed. I'd call it upscale, 3,000 to 5,000 square foot homes, 3 to 7 acre parcels of land with green space. Bayswater has been pursuing surface locations out here for a long time. Initially, we contemplated developing this 1280 spacing unit in 2 surface occupations, one from the north, one from the south. We worked hard, acquired some of these surface locations, but ultimately settled here on this green parcel. I think it was a very robust alternative location assessment. The staff agreed with that and concluded that there aren't any alternative locations that more successfully avoid potential impact to receptors. So that's a quick overview of the surface. I wanted to spend just a second on our timeline here. We've been out here for a long time. We started trying to find surface locations in 2018. Chased several of them, finally got the surface location that appears in our application. We staked that in February of 2020. We filed our old rules, Form 2A, in November of 2020. The review of that old Rule 2A was paused in January because we needed to follow the new rules. We got the OGDP filed in March. On March 15th, we attained completeness in July 15th, on July 15th of this year. And then the director recommendation came out about 10 days ago. Back in January, we did receive our 1041 WOGLA on January 21st, and we held a series of outreach meetings with the impacted stakeholders. So again, out here a long time, and as a result of the amount of time that we've been out here, we recently discovered a 10th RBU that had been built and occupied after Bayswater staked the location and submitted the initial Form 2A. So our application material and our maps, et cetera, supporting documentation all talked about 9 RBUs within 2,000 feet. There's the 2,000 foot circle on the map here. And then again, recently shooting some drone footage out here to help us with this presentation today, we discovered the 10th RBU. Fortunately, that RBU owner was included in all the notice, all the outreach, so fully informed of the process and had no objections. We notified Director Murphy and their staff of the situation. Immediately, we filed an amended application, and what we're seeking today is a conditional order subject to Bayswater updating the Form 2As and 2Bs. And as you can see where this RBU sits amongst the others that were part of the application material, the best management practices designed to protect those folks, and the folks in the HOA are certainly protective of that person. So we certainly learned a lot along the way. We've made some internal process improvements, on-site update, post-staking, and pre-OGDP filing, drone footage, the 2,000 foot setback during the process. So we've certainly learned some things. It's a dynamic and long process. Activity on the ground doesn't freeze just because we filed an DP or we've staked a location. And we think we have a good solution here, and we appreciate being able to move forward under this conditional order. A little bit more on our community outreach, the effort that we made. We held a virtual town hall meeting in January this year with the town of Severance, Belmont Farms HOA, and the Weld County Oil and Gas Office. We followed up with a broad invite list, invited a number of stakeholders to a second town hall meeting. It was well attended. We discussed our plans, the BMPs, the length of time we're going to be in the field, offered folks contact information, additional fact sheets and information, and offered to take those people attending the town hall out to the field. The town of Severance took us up on our field tour, and we visited active Bayswater drilling, completion, and production sites. So a good community outreach effort. Part of the feedback that we got from that community outreach effort, we implemented and amended and improved our BMPs. One, we restricted our planned haul routes to avoid County Road 23. That was important to the HOA and important to the town of Severance. We also agreed to implement some visual mitigation, some landscaping along that west side of our surface location to improve the vista from the HOA there. We've continued to update the town of Severance and Belmont Farms as to time. We've been in touch with them very recently. We didn't encounter any language barriers with minority populations as we conducted our outreach efforts. And again, we've had no further comments or concerns expressed during the process. Finally, touching just very quickly on some best management practices, we are going to surround the location with 32-foot high engineered sound and light walls. Those will keep the noise levels well below what's permissible by the Cogcc. Similarly, directing our lighting downward and inward, and that keeps the light impacts well below the levels limited or imposed by the Cogcc. We're going to utilize quiet frac fleet and sandbox technology to mitigate noise, air, and dust impacts. We're going to move all the frac water, the fresh water, into location via temporary surface pipe, and thereby avoid a great deal of truck traffic. And then all produced oil and gas is connected to pipeline at first production, again, minimizing emissions associated with hauling via truck. We are implementing continuous air monitoring using the Canary LLC technology. Bayswater was an early adopter of continuous air monitoring with Canary, and we've had Canaries on most of our sites, production and pre-production, since 2020. And then by design, all of our facilities are designed such that gas and vapors are captured, compressed, and sold in the sales line. So we keep all the hydrocarbons in the pipe. The thief hatches are closed, latched, and sealed during normal operations, sealed and ventless, and everything. All the vapors are captured in a vapor control system and compressed and returned to the sales line. So those are highlights of our BMPs. Certainly entertain more questions on those. So I think in conclusion, then we conducted a robust community outreach effort. We responded to concerns. We improved our BMPs, given the support of the local 10 RBUs and no objections. We submitted this OGDP application pursuant to Rule 604B4, and we're confident that our first class BMPs and operational plans, those were modified in response to community feedback, satisfy the approval criteria of Rule 604B4, providing substantially equivalent protections with the plans. The Cogcc staff and the director also appropriately determined that the proposed site-specific BMPs meet the criteria 604B4, and that we provided residents of the disproportionately impacted community a robust opportunity for participation in this planning and permitting process. So that concludes my summary remarks there, and I do have colleagues and counsel standing by to answer any questions if the commissioners should have any.
Thank you, Mr. Struna, for the overview and the presentation. Really appreciate that. Before we open you and or your colleagues to questions, I'd like to get Director Murphy to speak a bit about this project. This is the first that is attempting to comply with 604B, the substantially equivalent. Would like to get some commentary from the director about that. I would also like to get comment from Director concerning the sort of late discovery of the 10th RBU, the residential building unit that is within 2,000 feet, and get some perspective from the director of, noting that that was, noted late, but noting that there were BMPs that the director found sufficiently protective of the 9 other, the question becomes, are those BMPs sufficient for 10 versus 9 or 9 or less? And so those are my initial questions for the director to provide some additional commentary on. And then we appreciate you and your team standing around. You probably have questions, but that way we'll kind of have heard from all sides.
Thank you, Chair, and thank you for the question. I guess in terms of kind of the technical components of the OGDP, the director's recommendation contemplates those different pieces. And if we want to talk about the specifics of those, I would want to call on, Ms. Trask or somebody on her team. It was an interesting opportunity to learn about how to deal with a change in facts or change in circumstances in an OGDP process. This is not the first time in the review of a 2A facts have changed as staff's review has been undertaken. The review on this did take a little more time than I think any of us want a process like this to take going forward. But as Mr. Struna noted pretty eloquently, we all learned a lot along the way. And that for me was the most important component out of the discovery of the 10th building unit. When Bayswater discovered it, they immediately contacted us, which I'm eternally grateful for. It gives us the opportunity to take a look and provide feedback. And to me, there are kind of 2 different paths when it comes to an identification of a change in circumstances, change in fact. One is, is it a substantive change that would necessitate a change in BMPs, in which case staff would immediately ask for more time to conduct that type of review? Or is it a change in circumstances that the BMPs as designed and recommended and agreed upon would contemplate providing adequate protection? Categorically, we found this change to be in that secondary category. As soon as Bayswater contacted us, we convened our team to talk about what we knew about the location and what we had learned about the particular additional building unit identified. Important in staff's consideration is that the BMPs we designed were designed to protect any resident within that kind of 1,700 to 2,000 foot radius. And because we were contemplating protecting the neighborhood, we felt confident in the BMPs that had been proposed for the other neighbors in proximity. The other components that were really important to staff in its review was the level and degree of outreach between Bayswater and the community. I think that this is the demonstration of how important it is to have an effective communication plan. There was engagement, there was a lot of dialogue, there were opportunities for both the newly discovered building unit owner as well as the neighbors to engage in this process and participate. So under those circumstances, we thought it was entirely appropriate to bring forward this OGDP for your consideration with the BMPs that have been recommended to protect any resident within 1,700 feet, essentially, or in that 1,700 feet to 2,000 foot radius. And then ensure that the information is updated and is consistent with the facts as we understand them on the ground, which is why we think it's appropriate to have an approval with a requirement for Bayswater to come forward and provide that additional information conforming the information in our system to what we understand to be on the ground. So that's a bit of a long-winded answer, but I think it's an important demonstration of circumstances that are going to continue to arise for this commission, and that, I mean, we can think of an example that we're all pretty familiar with right now, a raptor nest, a new raptor nest is identified. And in that circumstance, we'll have to go through this similar analysis. Do the BMPs already contemplate protecting this particular receptor or not, and tailor our responses accordingly? But thanks for the opportunity to explain staff's perspective on it. I'm happy to answer more questions or at least Volin choose staff if you have more technical questions. And I know that Mr. Strunen and his team are standing by to also dig in on those technical questions.
Great. Thank you, Director Murphy, for that overview and insight as to staff's approach here. Looking to my fellow commissioners for questions for either Mr. Strunen, his team, or staff. Commissioner McGowan.
Thank you, Mr. Chair, and thank you for being today to walk us through your OGGP proposal. I just had a couple of questions based on things that I was reading, and I'm just trying to make sure I understand everything in the proposal. My first question is, I believe that there's a residential building unit 558 feet away, and I think it's the one within the yellow circle, but I don't think that's the surface owner. Is that correct?
I'm going to defer that one to either Mark Brown or Tyler Hammond if they can answer that question.
Let's do this, Mr. Strunen. I think we need to elevate these other individuals to panelists. So why don't we go ahead and elevate anybody that you think may need to be responsive? That way we can start answering questions with all of the right individuals in the panel. So
I appreciate that. Thank you. So those that are in attendance that I'd like to be have available to answer questions would be Mark Brown, Don Barbula, Brad Rogers.
Right. So, hold on just a sec. I want my manager to be able to catch them all before you go. Okay, we got Mr. Barbula. We've got Mr. Brown. Who's next?
Brad Rogers.
Brad Rogers. We've got Tyler Hammond. And we've got
finally,
Brad Rogers.
And then Joe Priscilla. Should we need Joe?
Mr. Priscilla is already on board, so I think we have everybody. If the other three want to go ahead and show themselves, or at a minimum unmute themselves, and then whomever of the team is most appropriate to answer this initial question, have at it.
Yeah, this is Mark Brown. You are correct, Commissioner McGowan, that surface owner to the south there is not the surface owner of where the pad is.
Thank you. And so as part of your outreach efforts, and I know that, sorry, I'm gonna have to go through my notes again and see, of the 9, now 10 RBUs that would be affected, there was a good number, I think 6, that participated in your Zoom meeting. And I would like to know if you know if that particular homeowner was a part of those discussions, because to me, that homeowner probably has the highest impact because they are the closest.
That homeowner was not in our town meeting. The actual homeowners that participated in the town meeting were the ones that were in Belmont Farms. I have had conversation with the closest homeowner there to the southeast as recently as a week ago, because we were doing some ambient sound monitoring and placed an ambient sound monitor in his yard. So we have had conversation recently with him.
And do you mind just sharing kind of how those conversations are going with that landowner? With that,
he's been supportive of the application. Understands that concerns about nuisance of sound, lighting, traffic. We've had all those conversations with him, but have assured him that with our BMPs that we are putting in place, that we will have his site protected, and also open communication during any operations if he has concerns.
thank you. I think that there was a comment by staff, maybe in the director's recommendation, that the surface owner has not explicitly signed a document that waives the within 150 feet from the property line. And I think they requested that that be done, and I was wondering if that had been achieved.
Yeah, this is Tyler Hammond. So yes, we did reach out to the surface owner and were able to get that waiver, and that property line is actually down the middle of our operations area there. And we have a signed waiver that allows us to put those wells within that property line now, and that'll be included in the updated application.
Thank you. And then I personally, and maybe the other commissioners are not having this issue, I am still struggling to understand kind of the difference between a drilling and spacing unit and a wellbore unit. And in this instance, why there's 20 horizontal wells within the DSU, but then the request, I think, if I'm understanding, 4 additional wellbore spacing units, and why there wouldn't just be one request for 24 wells within one drilling and spacing unit. And so if you could maybe clarify for me how that works and why the 4 wellbore spacing drills are necessary.
Sure, I think maybe this is best answered by council. So under the new rules, the commission did away with the concept of the wellbore spacing unit for the GWAP. And now it's just drilling and spacing units that can be of any size or shape, subject to modified setback requirements. And so for purposes of development, in this scenario with the requested setbacks, there's already an established drilling and spacing unit for sections in 13 and 14. That we're just asking that drilling and spacing unit be modified to allow up to 20 wells in the unit with 150-foot setbacks on the eastern and western boundaries, and then 460-foot setbacks on the northern and southern boundaries. And then the wellbore spacing units, they're technically under the rules, they are drilling and spacing units, but they're wellbore specific, and they would then be located on the edges of the drilling and spacing unit. And those setbacks then allow those wellbores to be 150 feet from any other wellbore, and then again 460 feet to the north and 460 feet to the south. And it's really the best way to protect correlative rights and avoid waste. And it's one of the many tools that are allowed under the rules, and we determined that was the best way to establish drilling and spacing units for these lands, to make sure that we're capturing the most resource and avoiding waste, but also to make sure that we're protecting correlative rights.
Okay, and so I appreciate everyone's patience, and I apologize if everyone already understands this and this is a Karen thing. Those 4 well bores, those WSU requests allow you to be closer to the buffer of the drilling and spacing unit, if I'm understanding correctly, but you would still have to somehow notify an adjacent mineral owner because you are closer to the buffer. So correct me if I'm wrong. And so for those 4 well bore units, did you have to then contact the mineral owners who are adjacent to the drilling and spacing unit because you're now within the buffer and talk to them about their correlative rights and possible impacts? Sorry, I'm really just trying to understand, and I apologize if I'm making this more difficult than it needs to be.
Not at all. So as the wellbores come closer to that section line, we effectively took the wellbore spacing unit concept under the prior rule 318A and applied it here. So the mineral owners that are north of the section line are included in those wellbore spacing units. So the quarters along in sections to the north, it would be 12 and 11, 12, I believe. And then to the south, it's 23 and 24. So those mineral owners are actually going to, not only did they receive notice, but they're also receiving a share of the production from those wells. Because if we just move the well bores closer to the line without creating these well bore spacing units, and we had asked for reduced setbacks, let's say 50 feet to the drilling and spacing unit boundary, those owners would not share in the production. So we believe that this is a more fair and equitable way of not only developing more resource, but also making sure that everyone's correlative rights are protected.
Okay, that makes better sense to me. So sorry. An alternative could have been under our new rules to expand the drilling and spacing unit to make it slightly bigger because you can overlap with other drilling and spacing units. Is that correct? Sorry, I just want to make sure I'm understanding.
You can, and that's in fact what we're doing with the wellbore spacing units. They are overlapping the drilling and spacing unit. I think one of the concerns that operators have is when you start to enlarge drilling and spacing units is correlative rights, is that as you are developing, there's always that concern that as you get further apart from mineral owners, that one mineral owner might not be treated, their resource is different, the well performance is different, but they could end up having correlative rights issues, you know, based on their location within the drilling and spacing unit. As you get broader, if it's not developed fully, things like that. So this is actually more, in our opinion, a more equitable way of developing the resources.
Okay, thank you, and I appreciate the information that you shared. And I have one last question, and that was, did you consider Ping and Aing any wells as part of the offset for cumulative impacts for this new activity? And if not, why not?
I think that question is better answered by Mr. Brown.
Thanks, Joe. We do plan, there's two vertical wells on the far west side of the DSU area that we will plan to plug and abandon as we develop this OGDP area. And really, this is a fairly undeveloped area from a vertical well standpoint. So that's really the limitation on what's out there currently.
Thank you. I think I remembered reading that. It wasn't in my notes. Thank you for reminding me. And then I, as a commissioner, am struggling with how we're going to start quantifying these offsets and the, you know, the plus and minus sides of the cumulative impacts that we're supposed to be tracking as a commission. And I'm wondering if there's a way for you to quantify the emission savings by Ping and Aing those wells. Is there a number out in the operator world that can be used as a surrogate until we figure out how to come up with emissions numbers for wells that get P&A'd, or some sort of modeling that can be done, or actual emissions put at the sites for a couple of days? I'm just trying to figure out how we're going to start tracking all this, because I think it's beneficial that it's being done, but I'm not sure how we're going to start quantifying it if we don't start asking for it. And that's my last question. Thank you so much.
I guess I'd ask Brad Rogers to try to answer that for us.
Yes, I mean, one way we could do it is look at the sites that are in the area that are expected to be plugged in from this project, and then be able to calculate either current emissions or emissions over, you know, the past year, or future projected emissions, and account for those. You know, if we didn't plug the wells, and kind of use that number as an offset, I think would be probably the best way to go on that.
That would be very appreciated by me, and I think that would be helpful to start tracking. So if that could be somehow calculated and shared with staff, that would be appreciated on my end.
Okay.
Thank you, Commissioner McGowan. I believe I saw Commissioner Nanjapa's hand next.
Yes, thank you, Mr. Chair, and thank you all for the answers to the questions and for being here today to walk through this. I had a question. I believe this was in the Wildlife Protection Plan. Sorry, I was just kind of scrolling through several things as we were just going through the other information. Okay, yes. So in, let's see, the section related to the original high water mark in the Wildlife Protection Plan, it notes there that new and existing oil and gas locations, operators will not situate new staging, refueling, or chemical storage areas within 300 feet of the ordinary high water mark. I actually looked at our rules because I thought it was different, and it is actually supposed to be 500 feet. But also your text in blue says frac chemical storage area is within 300 feet of wetland described. So that was a little bit confusing to me. Could you clarify on both of those points?
I mean, from a standpoint of our on-site storage, some of that will be potentially within the 300 foot of the canal that's there to the edge of us. But with the BMPs that are in place from a standpoint of liners underneath the drill rig, liners underneath the frac crew, bermed containment around any of that, we feel that that is protected from any type of spilling.
And so thank you, I appreciate that. I guess 2 follow-up questions then. If you could maybe from the location drawing, show me where, is the tertiary containment for the entire site, or is it just around certain tanks, or could you kind of show me where you're intending that to be constructed?
Well, there will be a BMP around the entire site that would collect anything that would run off of, if potentially that happened, that it would collect prior to running off the complete disturbed area, along with the drainage report and we needed to do for our 1041 Weld County WOGLA. Their requirement there now is also that we have a detention pond built on the site, which also is another capture area if there's a release of any kind.
Okay, and so that tertiary, just to be make sure that I'm really clear, it's surrounding the entire site, the tertiary containment. Is that correct?
Be a tertiary BMP around the entire site. Yes, that will funnel to a certain collection area.
Okay. And then the question again, then, as I noted, is that our rules actually say 500 feet, that you will not store within, will not situate staging, refueling, or chemical storage. But it sounds like you're saying that there will be chemical storage within 500 feet. I want to make sure that I'm understanding correctly, so correct me if I'm wrong. But then I would look to AAG Mercer or others. I think that would require a variance.
So Commissioner Nanjapa, I am looking at the rule you're discussing right now, and that 500 foot, so you are correct that at new locations, operators will not situate new staging, refueling, or chemical storage areas within 500 feet of the ordinary high water mark. And it sounds like this would qualify as a chemical storage area. Rule 1202A does provide that those requirements apply unless the operator obtains a signed waiver from CPW, Colorado Parks and Wildlife, and the director or commission approves a Form 4 sundry or a Form 2A documenting the relief. So it seems to me that here, if the commission approves the OGDP to include the 2A that allows the chemical storage to be at that location, that would satisfy that component. But I'm not sure about the status of a waiver from Colorado Parks and Wildlife, whether that's something that the operator has already obtained. If not, it seems that it would be required.
And could you clarify, I'm sorry, AAG Mercer, did you say, which was it that satisfied a portion of that?
So if you all, the commission, approve this OGDP, including that provision, if you approve the OGDP, that would satisfy the requirement that the location of this chemical storage be within 500 feet of the high water mark, because that can be done as part of a 2A, which is going to be part of the OGDP.
Otherwise, they require a CPW waiver.
So the way the rule reads, it says you need a signed CPW waiver and either an approved Form 2A or a Form 4 sundry. So it sounds to me like a CPW waiver is the outstanding requirement, unless, of course, the operator's already obtained that.
I know we had contact with CPW. I will have to double check on if there's actually a waiver. I don't know that.
Okay, so that is a pretty big concern for me. And I forget the name of it, that starts with a P, the canal that runs kind of along the site is an irrigation canal, as I understand it. So that would be a water of the state. So I think we need to be really protective of the potential for any chemical storage or containment of even just any upsets from the location to not reach those waters. Any thoughts or comments on that?
Well, again, I think from our BMPs that were in place, along with the construction of the site with the detention pond that's required on the drainage report from Weld County, I think we have protections in there such that we would have no chance, or minimal chance of anything reaching that canal.
Okay, and I guess I would look then maybe to Director Murphy or other staff if we could get any comments on potential evaluation of this aspect of the operating requirements under 1202A.
Director Murphy?
I've been chatting with staff. They may want to provide more specific input. My understanding is that CPW was engaged early, and I think that Mr. Brown was correct that we've reviewed it, contemplating protection, BMPs that would be protective. That said, I'm not sure that we have a waiver from CPW. It is something that I think we and the operator can reach out to and provide if CPW agrees. If CPW doesn't agree, that kind of creates a different scenario.
Okay.
If you want more specific comments about the design of the BMPs, I'm happy to bring either Doug Andrews in or Ms. Trask or Mr. Noto.
No, I think that was just the one thing that seemed to be in conflict with how our rules are written. And so I just wanted to understand if there was something that was inadvertently missed and if we need to take that additional step. And so, I will say that I do appreciate, the wildlife protection plan and the other measures that you all have taken and the consultation with CPW and, locating the area away from high priority habitat, et cetera. But, the location in proximity to the water, the canal in particular, and I don't know if any of you know if that irrigation area to the southwest is flood irrigation, but that would be, an additional area of concern, I guess, for me. I think, I guess I'm not sure what the right, we're new to this, as you all know, so I'm not sure what the next step is. So I'll look to you, Chair Robbins or AAG Mercer, as to what we do in this situation.
Well, I think what we need to do is exhaust all questions from commissioners. I've got some ideas about what to do on this front, and we'll also look to AAG Mercer. But why don't we can see if we've got any further questions from commissioners before we tackle that issue.
Okay, thank you.
Commissioner Messner.
Thank you, Mr. Chair. And thank you, Commissioner Najapa, for bringing that up. That was also in my notes as something that needed to be addressed as potentially a condition of approval should this go that route. I do have a few questions of the operator and then of staff. So understanding that we've got now 10 RBUs within 2,000 feet of this particular location, but a couple, I think in particular, and I think it's two, but correct me if I'm wrong, one just over 500 feet and one perhaps over 700 feet or just inside of 1,000 feet. And I might be wrong on that one, so please correct me if I'm wrong on that one. And so for me, this heightens my analysis of this particular situation. I will give credit to this operator for a well-done application and well-done description of the best management practices that are going to be utilized in this particular situation. I thought it was well thought out and certainly I think highlights what's possible with best management practices. But you did make the decision, the conscious decision, to look for an exception of Rule 604, utilizing number 4, which is substantially equivalent protections, versus number 1, which would have allowed you to gain consent of the property owners and tenants within that 2,000 feet. I'm wondering why you chose to go that route versus gaining consent, understanding that your best management practices are, great best management practices, and in my opinion, should be utilized by and modeled by operators, throughout that particular area. But I think you indicated in your testimony that you have support of these 10 RBUs, but I don't think I saw, at least in the application, that you have written consent from them or written support, which would have eliminated the need to be able to have the burden of proof to prove substantially equivalent protections to a 2,000-foot setback. So I wonder if we could get a little comment on that.
Who would like to tackle that?
Yeah, if I may, just for a short intro before turning this over to Mr. Brown. I think it's important to note that under the rule that 604B provides 4 options to pursue a location, and none of which are elevated over the others. In the statement of basis and purpose, it makes clear that the 2,000-foot buffer is appropriate in some circumstances and not appropriate in all circumstances. And that when you're analyzing the substantially equivalent protections, it's not a comparison against the 2,000 feet. It's just simply, it's evaluated on its own merits. And similarly, informed consent, yes, it's a possibility, but again, it's not necessarily preferred or elevated over any of the other options. And under these circumstances, with the level of outreach and engagement with all of these owners, and then included the BMP modifications in response to the feedback that was received from the community and these members, that Bayswater believe that the BMPs are sufficient to protect the public health, safety, and welfare of these folks within the 2,000-foot buffer in satisfaction of the rule. And that's the analysis that Bayswater had undertaken. But if Mr. Brown would like to add to that, feel free.
Yeah, I think Joe has defined that, the way we looked at it for sure. We have had a robust conversation or community relations with the offset owners. We have addressed their concerns as far as what feedback we did get from them. And overall, I would say it was fairly limited. And we just felt that from a standpoint of going forward to present this OGDP as a Rule 604 B4 application was the right process for us to do. And we're confident that our BMPs that are in place and the operational plans will protect the health, safety of the residents and all the surrounding parties there.
Thank you for that. I would go a little further then, understanding that we do have to make a determination of whether this is substantially equivalent. What are the different actions that you're choosing to take in this particular operation that would be over and above what you would typically do on an oil and gas location that would provide substantially equivalent protections in this particular situation?
I think, again, going back to our best management practices in general, the robust nature of what we've thought of here, what we need to do, and how we implement those in the field will satisfy that substantially equivalent hurdle. I think from the air side, the continuous air monitoring that we'll be doing, and the BMPs associated with there, that and the design factors in our facilities to capture all those vapors and compress them and back into the sales line is, an avenue that has presented itself and it is protective of the residents. Quite honestly, I mean, all of our sites are at the same level. I mean, whether it's one that's with 9 or 10 building units surrounding it, or it's a site that's without any building units, our design and our operations and our practices are still going to be the same.
Thank you for that. I wonder if I could just ask a little bit about the continuous air monitoring, and if you could provide a little more detail on what that means, where it would be located, and what it's actually looking for.
Yeah, I can expand on that. So we have a continuous air monitoring program that Steve alluded to, that we've been installing Canary units on much of our locations since 2020. For this particular location, we have submitted an air monitoring plan to CDPHE for their review, and they have approved that back in June. So for this site, we will have 4 monitoring units surrounding the pad that will be measuring or monitoring for VOCs, methane, and particulate matter. And then, we will have, based on the submitted plan, we will have alert levels that will be triggered based on the readings that the monitors are seeing. And these alert levels will be tied into a dashboard and tied into alerts that will be sent out to our field employees, so we can take immediate action and review what's be causing these alerts at that time and take appropriate action to mitigate or eliminate those alerts.
Thank you for that. So I think of particular concern to me is the tenant that is the closest to the site. And I think that there's been some communication with that tenant. Is there any particular BMPs that you're taking for those that are the closest to this particular site, specific to them, to create substantial equivalent protections versus those that may be 1,700 feet or further away?
One thing that came up because of that receptor that's just to the southeast of us there is the additional, we will have additional, I will say, temporary 16-foot sound wall panels on the interior of the site that will be placed near the point source of the noise, being the drilling rig shakers and the gensets, those kind of things, that help mitigate that closest receptor.
And any other BMPs associated to air emissions for this particular location and the closest receptors?
We can pull up the slide on the air BMPs, but as far as also the air monitoring, based on the plan that was submitted, we will have an air monitor between that receptor and the production site as well. So we could take that into consideration. Some other things we're looking at, is the use of electrification on our facilities that will help eliminate use of natural gas engines when possible. So we are working with our local utilities now to see what type of power capabilities we will have. But, it's anticipated we will have power to run our required vapor recovery and gas lift units using electric motors. So that will reduce noise and emissions associated with that as well. So, I think that's one that goes above and beyond. Also with our storage tank vapor collection unit, collecting vapors off our storage tanks and routing those back into our sales line is also above and beyond at this point, where we eliminate, our storage tank emissions to a further degree than just using a combustion unit. So that will be a significant decrease in emissions associated with those as well. Some of the others is looking at instrument air, which is taking Mac devices that are typically run off natural gas using instrument air, so we don't have the natural gas fugitive emissions associated with those as well.
Thank you for that. A question for staff. I think Director Murphy had indicated that there was sufficient substantial equivalent protections in staff's opinion between 1,700 and 2,000 feet. I guess I just wanted to confirm or understand whether or not staff feels like there's substantially equivalent protections for the closest receptors in this particular situation.
Commissioner, I'll take a first cut, and I think the answer is yes. If the answer was anything else, you wouldn't see a director's recommendation for approval. I think that the operator responded to the request from that specific resident, but I would be happy to defer more specific to staff for a more specific answer.
That'd be great for me if you would be willing. I'm just trying to fully understand, as I have to determine that there is a substantially equivalent protection here. I'm trying to understand from staff's perspective what are the elements that that they believe meets that requirement.
I think Mr. Andrews or Miss Merce or Miss Trask would be appropriate. Sorry, I was reading Miss Mercer's name.
Why don't we work on elevating them and see if we have other questions from commissioners so that we're continuing to make good use of time. Commissioner Nanjapa.
Thank you, Mr. Chair. It's related. So I've also got, concerns related to this closest residential building unit. One thing I know you noted that you would have downward and inward facing lights. Could you describe kind of how or where those would be placed in the pad? I don't know if that's something you could show me via the location diagram or just kind of generally describe that. In other words, are they sort of below the wall, the 32-foot walls? Do they stand above? Are they all around?
Sure. During the drilling and completion phase, obviously the 32-foot walls that surround the perimeter of the site will direct a lot of light mitigation, or minimize a lot of light spilling out through outside of that pad area. The drill rig obviously will have, the derrick will be above that. Those lights, we will not be using a crown lighting, which is a top of the mast lighting, which we have done in the past. At this site, we will not have that on the rig, and the lighting that will be on the derrick and stuff will be needed there for safety, but should not be directed per se outside of the top of the walls. During completion, everything will be inside of the sound walls and below the 32-foot height. From that standpoint, the truck traffic and everything that comes into here again, from the closest receptor to the south will be protected again by the wall. They should not have any truck traffic light that would hit them. Quite honestly, the canal that's there, the resident sits down lower than the canal. So, and we are up a little higher. So again, direct line of sight there should not be a direct line on the surface of our site to his site. So those are all taken into consideration, and are in our lighting plan has all of those sources outlined in the light plan.
Okay, thank you. I appreciate that additional description. And, especially with respect to the line of sight, thinking of the housing development on one side and with some of these other residents kind of, on another side, if the lights were, even if they're pointed down and in, they could potentially be pointing directly toward some of the residents. So that would just be something I think that
Sure.
we need to think about as well.
I think we have Ms. Trask with us now. Ms. Trask, good to see you.
Thank you. I appreciate being here. And thank you for the questions, commissioners. I did want to clarify that staff does believe that the BMPs proposed in this application will sufficiently protect those nearest building unit owners, not just the 1,700 to 2,000 feet building unit owners. We have reviewed these BMPs very thoroughly. We've worked with Bayswater in revising and upgrading some of the language in the BMPs. One thing in particular I do want to note is the takeaway capacity pipeline to minimize truck traffic. I think that will be and minimize emissions. That is a really big component that we were hoping to see in this application, and we do have it. So that was, I think that's a win for Bayswater and for us and for the local residents in this area.
Commissioner Messner, did you have any follow-up?
Thank you, Mr. Chair. Just one follow-up, and just helping me understand the analysis process. As you looked at this application and looked at substantially equivalent protections, are there expectations that you have in an application for receptors that are as close as just over 500 feet versus some that are further away, and specific modifications that you request in those particular situations that this application has met?
Yeah, we do. Thank you for that question. I think one of the most important components that we wanted to see in this application, and we feel that we did see, was communication. Bayswater repeatedly reached out to all the residential building unit owners, particularly those closest. They did make modifications to their plans, modifications to their operations and their BMPs based on feedback from these nearby residents. And so for us, that is a sort of a critical piece. Although they didn't get informed consent, we didn't feel that the rule required informed consent. This certainly is 604B4 is the commission's decision. But staff does feel that the communication efforts, the continued outreach, the invitations to the residential building unit owners to participate in this process have been adequate and have been sufficient for us to anticipate that these operations will be protective.
Thank you, Ms. Trask.
Thank you, Ms. Trask.
Commissioner Hackett, sorry, you're over on the corner of my page. I didn't see you.
Thank you, Chair Robbins, and thanks everyone for the discussion so far. Also did want to thank COGCC staff and the director for the diligent review and the thoughtfulness that went into the director's recommendation. And then Ms. Trask specifically wanted to thank you for helping walk me through how to access documents and going above and beyond there. That was really helpful. I did have some questions about the best management practices. I think they're best addressed by representatives from Bayswater. Kind of wanted to highlight it. Sorry, I apologize in advance. It might take me a while to get to the questions, but my understanding is from an emissions avoidance mitigation standpoint, part of your elevator pitch, if you will, for how emissions might be mitigated or how they will be substantially equivalent protections. You note that by connecting to a gas gathering system, delivering fresh water to the location via pipelines for completion operations, prohibiting trucks idling when not in use, and using electrical power at the site, you'll be reducing impacts from the oil and gas operations. You also noted on the Form 2A that if a produced water pipeline becomes available during the production phase, Bayswater will connect and transport that product through the produced water pipeline, which will eliminate the need for trucking of produced water at this location. So I think the first question I have is on that piece about if a produced water pipeline becomes available. In reading that, without seeing much more discussion that went into, the work that's gone so far about piping produced water out, to me, that alone kind of sounds very speculative and really doesn't sound like much more than wishful thinking. So I'm hoping maybe you can elaborate a little bit on how likely is it that produced water pipeline will become available, and what sort of conversations have you had so far to achieve that and put it into practice?
Yeah, we can take a stab at that, Commissioner Hackett. We've had explored lots of various options for produced water takeaway out here, talking to third-party gatherers, and also explored the idea of a company-owned produced water infrastructure, and have not to date been able to come up to an economic solution to get the produced water takeaway into the ground. The closest saltwater disposal well is approximately probably about 15 miles from this site as far as pipe that would have to be put into the ground to get it there. And right now that facility is actually limited on free capacity because it's already contractual obligations to some other operators. We continue to recognize that this is an area that needs help in the basin, not just at our site, but all over as far as water takeaway, and continue to explore those. The probability of it at this point, I would say it's probably less than 50-50, but we continue to look at those options.
Thank you for that, Mr. Brown. And again, produced water pipelines is definitely not something that's required by the rules, but just kind of wanted to flag for future discussion that if and when a CDPHE consultation is triggered under COGCC rules, that level of detail that you provided there is the type of thing I would be asking for when I would do my review. So did appreciate your response on that. Another question I had is concerning vapor recovery. The Form 2A on the site equipment list section, it lists that there will be 0 vapor recovery units and 0 vapor recovery towers, but the narrative form of the form on the Form 2B, the BMP list towards the end, it does reference vapor recovery units. And then also in your presentations today, I think you kind of use the words vapor recovery system and vapor recovery unit interchangeably. So can you shed a little light on that? Are these vapor recovery units the same as a vapor recovery system? And is that perhaps a typo in the Form 2?
Well, that was probably an internal issue there between vapor recovery unit and compressors. The compressors that we are using for vapor recovery on site are listed as a compressor on the 2A versus as a vapor recovery unit, because a vapor recovery unit is essentially a compressor. And we just from a nomenclature standpoint, we ended up calling those all a compressor. And I fully understand that we've had VRU, vapor recovery, kind of interchange, but they will be used for vapor recovery, but is listed as a compressor on the 2A.
thank you for that clarification. That is helpful for me at least. Then I did have a few more questions, and let's see here. I had a question about the tanks that will be on site. This is a similar question that folks might be have heard before, but again, this is something that's not required by the rules, not required by an Air Commission rule or a Cogcc rule. But I'm curious why this blend facility can't be tankless. What are the barriers there? Why isn't a tankless facility necessary or reasonable in this case?
Yeah, I would say, from our standpoint, basically Bayswater, we don't have the scale or the acreage position up in here to put into place that more complex infrastructure to gather from multiple sites and then process that flow stream at a consolidated site. From that standpoint, we need to have some storage on site. We will have a what was mentioned, the oil takeaway pipeline. So we will be selling through a LACT site, a LACT unit there. But even with that, we need some storage as far as on site, drop those pressures down, capture those vapors as they flash before it goes through the LACT into the pipeline. I hope that answers.
It does. That's helpful. Thank you, Mr. Brown. And just to be clear, I did want to take note of the fact that a lot of the BMPs that are being proposed in this facility, those are things that we didn't see very commonly before the mission change rulemaking. So just did want to highlight for folks that we are making some progress there. And these are some BMPs that it's encouraging to see now that we have the more stringent mission change rules, and we're hoping to see more widespread adoption of those types of kind of top shelf best management practices. So just wanted to highlight the positive note there. And then another thing that I did want to flag in the Form 2B, and this is kind of more of a pet peeve of mine, and again, not something that is required by the rules, but in the qualitative evaluation on the Form 2B of potential health impacts, you did cite 2 CDPHE studies, but you only mentioned the results from one of the studies. The study that you didn't mention the results from was the 2019 modeling study that was funded by CDPHE and completed by our contractor ICF International. That study found that potential for acute health risks at all model distances out to 2,000 feet. And just want to be clear, I'm not suggesting in this case that there will be negative public health impacts, and I understand that there will be more protective measures in place at the blend pad than perhaps there were at the facilities that were monitored for that 2019 CDPHE study. And I also did acknowledge that in the 2B, you did mention the CTEH study about the compilation of benzene measurements near well pads in Colorado. But I did just want to highlight that the main conclusions from that 2019 CDPHE study has not been fully or comprehensively tested by real world measurements to entirely, completely 100% rule out the potential for acute health impacts. And just wanted to note, I definitely understand the challenge and the scientific uncertainty involved in the qualitative assessment component of cumulative impacts. And CDPHE certainly is very mindful of the limitations of the 2019 study. But I did just want to be clear about what that study did and did not say. And I guess I would encourage operators going forward, if you do explicitly mention the results from the 2019 study, or excuse me, the 2017 study, I think it would be prudent to also explicitly mention the results from the 2019 study to keep things in context. And again, that's sort of just one person's opinion. Don't have any specific questions from that, but did want to give you an opportunity to respond if you'd like to.
I will say so noted.
And sorry, Mr. Chair, I'm just looking through my notes. I think those are all the questions I had at that point. Thank you so much for the responses.
Thank you, Commissioner Hackett. Further questions from commissioners? Okay, I think we've exhausted our questions at this time. And so I'm trying to figure out what we should do next. Do we want to dismiss the panel and have discussion amongst ourselves with regard to where people may be sitting with regard to evaluation of this matter before we move to PDC. Yes, Commissioner McGowan.
Sorry, Mr. Chair. Can I ask one more question before we move on? Sorry.
Yeah.
Could I confirm, and it's hard for me to do two things at once and try to listen and pay attention, then go back and look at my notes and look at attachments. Can I confirm that the folks within the vicinity received communications from Bayswater that explained to them the commission's process and their ability to testify with the commission if they had concerns or opposed this permit application?
Mr. Pershala?
Yes, I'll take that. Yes, all notice as required by the rules under 504 and rules 303 were provided to all interested parties, to all surface owners, to these individuals that are located within the 2,000 feet. So they definitely had not only opportunity to participate in the meetings that Bayswater had held, they were also provided adequate, proper notice under the rules of this proceeding. They did not file petitions, they've not filed public comment, or in any way indicated informally to Bayswater that they have any concerns or objections to the application of this hearing process.
Thank you.
Thank you, Mr. Pershala, for the answer to that important question. Anyone else? Commissioner Nanjapa.
Sorry, that just got me thinking. You know, in thinking about, as it relates to both Commissioner McGowan's and Commissioner Messner's earlier question, because you didn't do, you know, the informed consent process, we have a template for the informed consent that includes, you know, some of the same information that Commissioner McGowan was just asking about, but also specifically lets them know that they are considered affected parties. Was that part of your notice and explanation to the residents?
Mr. Pershala?
I think Mr. Brown is in a better position to answer part of this question. Obviously, the notices that go out with respect to under the rules include everything that are thereby required by the rules, that they are interested parties, that they do have rights to, one, consult with Bayswater, but also to file petitions and otherwise participate in the process. And I do know that as part of Bayswater's outreach, and I think Mr. Brown can speak to it a little bit more importantly, or more clearly, there were documentation, documentations on hydraulic fracturing, oil and gas development, impacts of oil and gas development, including, and my understanding is the Cogcc form as well as the COGA form were provided to these owners. But I'll let Mr. Brown answer further.
Yes, just to confirm that when we started that process with the communication, you know, to the residents, I mean, the close ones and those within 2,000 feet, you know, that was back when we were doing, you know, the director's criteria within 1,500 feet. And most of those building units fell outside of that 1,500-foot circle at that point in time. But we felt that it was necessary to, you know, bring those people in and tell them what we were doing, give us the plans, and we did send to them the I don't remember the verbiage exactly, but the, you know, building units that were within 2,000 foot of a planned oil and gas operation. We provided that to all of those within 2,000 foot. We provided that to the HOA to circulate to any other members that they wish to circulate it. They actually, I believe, I won't guarantee it, but I believe they posted that up on their HOA website. And so all of those parties were, I would say, notified that there was going to be oil and gas operations within, you know, proximity to their building units. I don't know if that answers your questions, but we tried to make sure they got all the information.
If I may, Mr. Chair.
Yes, Ms. Mercer.
Just to try to provide a little more context specific to Commissioner McGowan and Commissioner Nanjapa's concerns, Rule 303E specifies the notice necessary for an OGDP and what needs to be provided in that notice. And it includes a couple of COGCC information sheets. One about the procedural steps involved in review and approval of an OGDP, another about the ability to submit public comments, and another on how to monitor the status of the OGDP on the website. So I can't speak to whether all of those forms went to the required parties, but it sounds like the parties are here saying that they have, and so provided that that Bayswater complied with the requirements in Rule 303, all of those residents should have obtained the information that they needed to know what was going on with our process.
Yes, to reiterate that letter that came out of Mr. Pachala's office was all sent certified to those affected parties, and with a cover letter with a description of our operational phases as far as what's happening on location, a projected timeline, a consultation form that they could reach out again to any of the Bayswater contacts that were included there. The local government designee was listed along with the Oil and Gas Commission. We had the COGCC information sheet, procedural steps for Commission's review of the OGDP. We had COGCC information sheet for public comment submittals, and information on hydraulic fracturing was included there. And those were all sent out, registered out of Mr. Pachala's office.
Thank you very much. I appreciate the thorough answer, and thank you, AAG Mercer, for that additional context. Appreciate it.
Agreed. Thank you both. Thank you, Mr. Brown. Okay, seeing no further questions, why don't we remove the panel, and we'll have the commission here ready for deliberation on this matter. Ms. Amaro, if you can help me with that, that would be appreciated. Thank you all for your presentations this afternoon and for appearing before us and answering questions.
Thank you.
Thank you.
Okay, I think in AAG Mercer, you might want to make yourself visible. We might have some questions for you. I think the first question that we have for ourselves is, does this remain as consent, given that at a minimum, we would have some conditions of approval or contingencies, such as if this were to be approvable, one condition needs to be, and I think an amendment to the Form 2A and 2B to reflect the 10th building unit. And I think another condition is that the approval would be contingent on getting a CPW waiver, as noted by Commissioner Nanjapa. And there may be others. I still think we can do that. It just would need to be in the form of an appropriate motion. I also think it probably makes sense, now that we've had a lot of discussion, is let's finish up this one and then let's go to PDC, so that we're not like mixing apples and oranges on that. And so I think with that, we're kind of in a place where we need to deliberate on what we've heard in terms of the application. I can start just because I'm already talking. I appreciate the director's review. I appreciate the level of communication as noted by Ms. Trask. I appreciate the fact that the residential building units, while they may be closer than 2,000 feet, were given every opportunity to have concerns, express concerns, and we received no protests. We received no written comment. We received no oral comment. I find that to be information that is helpful to my deliberations. I also, in my opinion, find that we have established through the sort of above and beyond BMPs that this is substantially equivalent. And I also want the world to know that this commissioner at least does not feel that, so in this operator, I'm finding an operator that's doing the right thing. And they even admitted that they do the right thing on all of their, all their proposals. I don't think you need, if that's the way the operator is operating, I don't think they need to then go like above and beyond what they're already doing, which is good. In other words, I'm not punishing somebody that you need to do more just to make it substantially equivalent. So I appreciate that. And I agree with Commissioner Hackett, having been director before mission change rules and looked at BMPs and seeing the BMPs that are here, that these are above and beyond where we were before mission change. And I find that to be helpful and instructive. I also note that on 604, there are 4 different ways to sort of get an out from the you cannot be within 2,000 feet, and they are independent of each other. I'm not going to get into the business model of why they didn't go informed consent. I've got some ideas, and instead they've chosen the path of substantial equivalent, which is its own independent path. I also appreciate the air monitoring and the use of the Canary system. I think that will be very helpful. So all in, I'm comfortable with where we are with this, with the contingencies that need to exist on any motion that would be for approval. So that's 2 cents from one commissioner. Can we get some sense from others and kind of where they may be? Commissioner Gonzalez and then Commissioner Najapa. You kind of raise your hand at the exact same time.
So it was close to a tie. Thank you, Chair. I agree with a lot of what you just said. I think for me, this is a really good example of seeing an operator come forth with a very thorough presentation to us, a very thorough outline of what their intentions are and what their plans are. I thought the engagement with stakeholders and with staff specifically, I think was pretty exemplary for this operator and resulted in what I thought was a well-supported recommendation from the director. I think under 604B4, it lists a whole slew of criteria that we can consider in considering whether or not we are going to grant this substantially equivalent determination on this OGDP. And having reviewed the OGDP package, the submittals, as well as the director recommendation, I think that there's a great amount of information in there that lends itself, and specifically, with kind of the above and beyond BMPs that this operator has put forth, that lends itself to my support for this OGDP under 604B4 and otherwise. So that's kind of where I sit on that.
Commissioner Najapa.
Thank you, Mr. Chair. I think I generally agree with what both you and Commissioner Gonzalez has said, and do very much appreciate the thoroughness of the documentation that was provided by Bayswater, and that they, really did a nice job of explaining kind of what they were going to do and how they were going to do it, and the visuals that went along with it, I think were really useful. I'm, already voiced about the water issue with the canal nearby and the CPW waiver potentially. I still am struggling a little bit with the residents that are nearby. While I understand that they, seem to be supportive, I have had meetings with affected parties in other places, other operators, where they, you know, kind of had a similar feeling, agreed to something, and then once it started, felt that it was more disruptive than they expected. So those are the types of things that I'm concerned about and considering with respect to our setback rule, and understanding that it isn't, you know, an or situation with our provisions in 604B. So I'm just sort of thinking out loud for the moment, and saying that I'm a little hesitant for that reason, as it relates to kind of other OGDPs that may come up. That said, all things considered overall, you know, I do feel like they've done a very good job, and I appreciate, you know, the director's recommendation and the comments from Ms. Trask related to that sort of substantially equivalent determination. So yeah, I won't say where I am quite yet, but I'll leave it at that for now.
Great, thank you, Commissioner Nanjapa. Commissioner Messner, then McGowan.
Thank you, Mr. Chair. You know, I think I had initially indicated when I was asking questions that I did think that the application that was provided by Baywater was a good example of a well-done application. I think the information that was provided there was good. I think the best management practices that sounds like were worked out between staff and Baywater were well done. I think that at least from what I heard from staff, the communication between staff and Baywater actually created additional best management practices that I think in this particular situation improved the situation that may not have been typical operating procedures from Baywater's standard operating procedures. I read hard both the application and the recommendation provided on this particular application. I do think the utilization of 604B4 to this commissioner requires this commission to provide, you know, additional analysis to the application, because this commission has to determine that there is substantially equivalent protections utilized in 604B4. And so that's why you heard me asking some pretty strong questions of the applicant as well as of staff, because it is ultimately then this commission's responsibility to make that determination based on a number of different criteria and also based on a 510 hearing. And so in this commissioner's understanding of the rulemaking that was provided or that we went through, that was an important part of the substantially equivalent determination is the 510 hearing. I do think that putting this in the situation that we did does meet that 510 hearing requirement. But I also think it's important that in those particular situations where an applicant is using 610B4, that we do ensure that the applicant has provided the burden of proof in order to meet the substantially equivalent determination. Should the applicant have utilized, you know, S604B1, then that 510 hearing requirement does not stand, and the RBU owners or tenants would actually be the ones making the determination whether or not they felt like there was substantially equivalent protections for their particular situations rather than the commission. Having said that, those are the questions that I was asking and what I was trying to understand through that particular situation. You know, I do think that, you know, the communication between this applicant and staff appeared to be strong. The coordination as far as ensuring that there was adequate best management practices. At this stage, I don't have any reason to disagree with staff's analysis, technical and desktop analysis, according to the director's recommendation, that there is not substantially equivalent protections provided both to all the RBUs within this particular application within 2,000 feet. I do think that the utilization of the continuous air monitoring and the targeted air monitoring, in my opinion, to the closest receptors, as well as any of the receptors, is an important piece of this. I do think that the utilization of temporary water pipelines to minimize truck traffic is incredibly important, and want to see that. I do have a question as to how you incorporate conditions of approval on consent agenda, and so I would be curious to hear from AG Mercer whether we can do that or not, but I do think that there probably should be a condition of approval placed on this application for the CPW waiver, as well as the modification of the particular application. And I do think that, well, I don't have any reason to believe that these 10 RBU owners or tenants within the 2,000 feet, do not support this, and there's no indication that they oppose it based on, the lack of protest or participation in this particular process. For this particular commissioner, the way that I would have known that for sure would be informed consent in this particular situation. And so that's where I'm at right now, and those are my thoughts.
Thank you, Commissioner Messner. Commissioner McGowan?
Thank you, Mr. Chair. So I'll just echo what my fellow commissioners have already said. I think, so again, not really knowing if this is going to be a consent item if we add some conditions. I think I'd like to add the condition that there's going to be some sort of emissions measurement in reductions for P&ing the two wells so that we can start tracking cumulative impacts. And I did understand, I think during the presentation, that Bayswater has emission monitoring equipment at the home that is nearest to the site. And I would request that that stay in place for as long as that is required by CDPHE rules, which I think is through 60 days, Commissioner Hackett, after production?
I believe 6 months. Let me just double check on that.
6 months, sorry, 6 months. And so I'd like that to stay at that location for 6 months after production. I'm particularly concerned about the residential unit that is closest to the site. If it was the surface owner themselves and it was their choice to put themselves that close to the site, I think I would have less heartburn about it. At the same time, I do think that Bayswater has been communicative. I think that their outreach has been an example of what we're trying to get at as far as working with community, informing folks. They also should have understood how to work with the commission if they disagreed or had concerns. And that's everything from public health concerns to nuisance concerns, et cetera. And so I'm also, I think that Bayswater has been thoughtful about how to try to minimize impacts to everybody that's affected by the 604B4 variance. I don't know if we're called a variance, sorry, pathway. And, they're using the quiet frac fleet, gas gathering system, piping in the fresh water to reduce truck traffic, no truck idling, partial electrification so we can reduce noise and emissions, which I think are all big steps when we're looking at trying to reduce impacts to folks who are within the 2,000-foot buffer. And so I'm appreciative of that. And those are my thoughts.
Thank you, Commissioner McGowan. So if I'm tallying up what I think are the additional asks, the conditions of approval, Commissioner Messer, you're aware of that from your county days. Often approvals were with conditions, and I think what I've got are potentially 5 One is that there needs to be an approved CPW waiver. 2, there needs to be an executed waiver on the parcel line setback. 3, there needs to be changes to the 2A and 2B to reflect 10 rather than 9 RBUs within 2,000 feet. And then we have Commissioner, so I think those 3 we all have already talked sort of about and are aware of. Commissioner McGowan just added an emissions measurement for the P&A wells to address cumulative impacts, as well as the requirement that the air monitoring to the closest RBU stay in place to stay in place until 6 months after production has initiated, which is consistent with CDPHE. So those are the 5 elements that I'm seeing that would be conditions of approval. I believe we can still, I think we can, have a vote at this point and do that as part of our consideration of consent and adding those to it. But I am looking at Ms. Mercer over on the right-hand corner of my screen and would like to get some legal advice on that issue.
Yes, Chair Robbins, I agree with your analysis that today in this hearing, you can approve the OGDP with those 5 conditions. I would add that it probably would make sense to make sure that neither staff nor Bayswater would object to either any of those conditions that you just listed before moving for a vote. But other than that, oh, and sorry, one other sort of more administrative matter is that the current hearing officer recommended order that would be approved subject to these conditions, that was entered before Bayswater submitted their 4th amended application. And all the 4th amended changed from the previous application was to note that Bayswater had secured the signed 604A waiver. So I would just note that the order should be updated to reflect that it is based on the 4th amended application.
Well, I think that the order needs to be amended to be consistent with the conditions as well as the 4th amended application.
Correct.
Is that fair? Okay. So let's start this way. Do any commissioner or does any commissioner have any additional addition other than the now 6th, because the making the hearing order consistent would be the 6th piece. Is there anything else from a commissioner that you believe needs to be discussed? Commissioner Gonzalez?
Thank you, Chair. Yeah, just a point of clarification. One of the 5 COAs that was listed or enumerated was the waiver of that 604A2, the surface owner property line within 150 feet. And then the 4th amended order, I guess it contemplates that waiver has already been signed. So would both of those conditions of approval need to be a part of our order or a part of a motion to issue an order?
AG Mercer?
I think so, just insofar receiving the signed waiver is something that I would consider a COA, and just revising the order to reflect that it's with the 4th amended, to me, that's more of an administrative matter that the hearings unit can take care of. So I wouldn't necessarily consider revising the order to reflect the 4th amended to be a COA, but I would consider the waiver to be one. Does that make sense?
Yeah, I think my understanding was that the waiver has already been obtained and that was reflected in the 4th amendment, in the 4th amended application. And if that waiver has already been obtained, then wouldn't it not be necessary as a COA?
So yes, if staff has already obtained that waiver, it would not be necessary as a COA.
That might be the point that I'm missing, is that,
Bayswater
has received it, but staff hasn't received it. And I think that answers my question. I'm sorry for the convoluted questions there.
No worries, and it looks like maybe Director Murphy can clarify that for us.
Director Murphy?
You're correct. This came in after we had finalized the director's review, and so we wanted Bayswater to submit it to the commission for their for your understanding that it has been obtained. And then if approved, file it back with the actual 2A. This is about marrying up our two systems. Commissioner Gonzalez, if that helps.
Okay, and hearings manager Amaro, if you could bring Mr. Priscilla back to the panel, or Mr. Struna. I want to follow up on the good idea from AAG Mercer. And Director Murphy, while you're still here with us, you've heard the discussion. Does staff have any issue with the 5 or 6 different elements to the potential for a motion?
Chair, I don't know if you want us to chime in first or to hear from Bayswater.
Now that I've got Priscilla with us, Mr. Priscilla, do you want to speak on behalf of the applicant? And hi, Mr. Sterno, you as well.
Yes, we've conferred and we're agreeable to the conditions. And I thought I would just make clear as well on this point about the surface owner property line waiver is that, yes, that is in hand, and the intention was to submit that following this hearing. We just didn't want to, it was the direction from staff to hold off on submitting that until after we proceeded here today. So we do have that in hand.
Very good. Okay, Director Murphy.
Chair, I think staff is comfortable with the modifications proposed. We wanted to make sure we're clear about the emissions monitoring component around the P&A, and wondering if something along the lines of Bayswater providing a sundry form for per well estimate of emissions reduction by P&Aing the wells is the right language, or if that accomplishes Commissioner McGowan's goals. And it helps us understand the process by which to bring it in and what the expectations are.
Commissioner McGowan, this was your issue. Do you want to?
Yes, thank you, Mr. Chair. So assuming that they can only estimate instead of putting actual emissions equipment next to the wells and trying to get an actual reading, yes, that's acceptable. Some way for us to measure emissions reduction by P&A in the well. And if the Form 4 works best for staff, that's great.
Okay. Anything further from commissioners, the applicant, or the director at this point? And Commissioner Nanjapa?
Thank you, Mr. Chair. Not a condition, but just general encouragement to Bayswater to continue the great communication that they have been conducting with the residents, especially as it relates to new operations that are going to commence. I think that'll go a long way.
Good note. AAG Mercer, I'd like to go ahead and take a vote on this at this point so that we're not mixing this application with the next one. Is that okay?
Yeah, I think that's the best course of action.
Okay. All right.
And Mr. Chair, I would suggest repeating the list of COAs that are going to be part of the motion, just to make sure that that's clear in the record.
Right. So I'm looking for a motion that includes the following conditions, or a motion to approve with the following conditions of approval: adding an emissions measurement for the plugged and abandoned wells consistent with the direction from Director Murphy, adding a requirement that the air monitoring system stay in place to the closest residential building unit until a minimum of 6 months after production, consistent with CDPHE rules, obtaining a CPW waiver for the water body, right? Commissioner Nanjapa, is that right? Presenting the executed waiver for the 150-foot parcel line setback from the impacted owner, and amending the 2A and the 2B to reflect the 10 RBUs as opposed to 9 RBUs, and with the hearing officer order to be amended consistent with the 4th application, as well as these conditions of approval. How to do, AAG Mercer? Commissioner Nanjapa.
Sorry, I don't know if this is necessary, so I'll look to AAG Mercer, but the CPW waiver was for the chemical storage within 500 feet of the ordinary high water mark. So just wanted to make sure that was clear.
Yeah, that's part of the motion that I'm looking for. Commissioner Gonzalez?
Just another point of clarification on the motion, Chair. For the emissions measurement, as you stated in the motion, I just kind of want to make sure that I understand the same, is that it is an estimate of emissions reduction from the P&A wells. Okay, I see nods, so I'm supportive of that. Since I have the floor, if there's no other questions, I'm happy to make that motion, Chair.
Please do.
So hereby move to approve the OGDP pending conditions of approval for the amended 2A and 2B to add the 10th residential business unit for the CPW waiver as stated for the chemical storage there on location for 6 months of air monitoring post-production, for a waiver of the 604A2 property line setback requirement, a COA for an estimate of emissions reductions for the P&A wells, and a COA that includes the fourth amended order, or excuse me, the fourth amended application by Bayswater.
And did we want to add in the 9 to 10 RBUs? Maybe you said that, but
I think I captured that.
Okay, good. Sorry, I was trying to knock them off. Okay, we've got a motion. Do we have a second?
Second.
We have a motion from Commissioner Gonzalez and a second from Commissioner Nanjapa. Do we have further discussion before a vote? Commissioner Messner?
Thank you, Mr. Chair. I would like to put a little context with my vote. And so I am going to vote to approve this application. I think that the discussion that we had and the points that I brought up and the answers that I received were compelling to me. I think it's also important to note that the HOA, the town of Severance, and the county of Weld County, which were all either local relevant or proximate local governments, as well as the associated HOAs, had opportunities to either make modifications, protest, or provide comment in opposition to this. None did. None of the affected residents within 2,000 feet provided comments in opposition or protested this particular application. And so that is one of the reasons that I will be voting to approve this particular application, as well as the associated best management practices and analysis that we've already discussed. But I did want to add a little context to that.
Thank you, Commissioner Messner. Others with comments? Seeing no further comments, all those in favor of the motion signify by saying aye.
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 Any opposed? Motion carries unanimously 5-0. Thank you, Mr. Struna. Thank you, Mr. Pashala, for being with us, and we wish you the best as you move forward. I would suggest let's take 5 minutes before we take up PDC. I could like to refresh my water bottle, if nothing else. So it is, let's come back at, what, 10?
Thank you.
10:45?
Mr. Chair, sorry. Uh-oh.
Sure.
We already lost somebody. I don't know. I just noted that it's 12:40. I'm wondering if maybe it's appropriate to just have a lunch break.
We can do that. What do folks think?
Even if it's just 20 minutes and come back.
Yeah.
So we
Okay,
can
so let's like come back at like 1:05. Does that work?
Great, thank you.
Give you a chance to build a sandwich. It is We've started the recording again. It's 1 o'clock, and I want to thank Commissioner Njapa for the excellent idea of taking a 20-minute break and getting a bite to eat. Brilliant. We're still waiting on one commissioner. While we're doing that, hearings manager Amaro, I'm not sure who we need to elevate to the panel in terms of PDC. If the PDC folks could raise their hand in terms of who needs to be brought to the panel, that would be great. I see Brian Cocchiere starting at the top, going down the list here. Okay, we're bringing folks in, so just bear with. And then Ms. Amaro, I do not believe we had anyone sign up for public comment on this matter. Is that correct?
That is correct, Mr. Chair.
Okay, thanks. Good afternoon, Mr. Storm. Do you know others that you're looking to get elevated to the panel?
I sent Ms. Amaro an email this morning. It should be Brian DeRose, Brian Cocchiere, Ms. Vanessa Chase, and then in the unlikely event we have to answer some leasehold questions, we may bring in Mr. Tyler Sims from PDC.
Okay. I see Ms. Chase, I see Mr. Cocchiere, I see that Brian DeRose is with us, although he's not visible yet. Hey there, Mr. DeRose. Okay, so I think we will, we have no public comment. So at this time, PDC has an opportunity to provide us with an overview of its OGDP proposal. We have reviewed the files. We have reviewed the director's recommendation of approval. And so we look forward to hearing from PDC at this time.
Excellent. Thank you, Director Robbins. I'm sorry, Chairman Robbins. Good afternoon, Commissioners. My name is Jeffrey Storm with Wilburn, Sullivan, Mekintuli on behalf of PDC Energy, Inc. And first of all, we'd just like to thank you for both you and your staff's time and attention to this project. The application before you in this hearing is an approximate 1,440-acre oil and gas development plan for development of the Niobrara, Fort Hays, Codell, and Carlisle formations within the Wattenberg Field, Weld County, Colorado. The OGDP covers 8 total wells, 3 spacing units, and 1 approximate 14.7-acre oil and gas location. The lands lie in Township 3 North, Range 66 West, Sections 9, 10, 11, 14, 15, and 16. PDC holds 100% of the working interest in unit numbers 1 and 2 in the application, and holds the plurality working interest with consent secured to the balance in unit number 3. The unit shapes and setbacks sought by this application reflect the collaborative negotiation by PDC and other working interest owners in this area. The location lies in a rural area of Weld County, Colorado, approximately 1.5 miles northeast of the town of Platteville. The location and the units allow for 3-mile horizontal development of the Niobrara, Fort Hays, Codell, Carlisle formations, with development of up to 1,440 acres from a single oil and gas location. PDC filed the Spinney Oil and Gas Development Plan application on May 14th, 2021. The application was subsequently amended in order to narrow and tighten the preferred language of COGCC under the new rules and to redescribe the surface acreage for the location. The director determined completeness on July 30th, 2021, and the commission issued a notice of hearing on the same day. PDC mailed the notice pursuant to the 300 series rules and the 500 series rules on or before August 6, 2021. PDC further published a copy of the notice of hearing for the application on August 4th and August 6th in both a local and a statewide publication. To date, PDC has received no protests to this application. Only one public comment was received on this application. It was that of Jason Maxey, representative of Weld County, Colorado, who is the relevant local government for the Spinney location. On September 22nd, 2021, the director, after full review of the OGDP, all supporting materials, and all public comments recommended approval of the Spinney OGDP application. And that's why this matter is now before you. This matter is now before the Commission for consideration pursuant to Rules 307A and B and Rule 508. With that context, I'd like to introduce Ms. Vanessa Chase. Vanessa is the regulatory manager for PDC, and she will provide some further detail on the Spinney OGDP application.
Thank you for the introduction, Jeff. Good afternoon, Commissioners. My name is Vanessa Chase, and I will be presenting an overview of PDC's Spinney Oil and Gas Development Plan. PDC has a long history of commitment partnership in this area, working closely with landowners, neighbors, local elected officials, and charitable organizations. Through the years, we have demonstrated our commitment to safe and efficient development. The Spinney Oil and Gas Development Plan's surface location is located in the southwest of Section 9, Township 3 North, Range 66 West. PDC has been planning this location since 2017, obtained a signed SUA in 2019, and then again reevaluated for alignment with the current mission change rulemaking. The primary current and future land use is non-crop dryland pasture. This location is planned for 14.7 acres total disturbance, with 11 acres being the working pad surface. There will be 9.3 acres reclaimed and given back to the landowner, with a total of 5.4 acres used for the production phase. This location provides the ability to develop 1,440 acres with only 8 horizontal wells. All production equipment will be on location with the wellheads. PDC also intends to have midstream equipment in place to pipe the oil and gas from location. Relevant local government approval was obtained on August 9th, 2019 through Weld County's WOGLA permitting requirements. There are no proximate local governments associated with this location. There are also no variances or exceptions requested within the application. PDC conducted a robust and thorough alternative location analysis, which included analyzing 5 alternate locations throughout the mineral development area. We found the proposed location to be the most protective, as there are no high occupancy building units, schools, hospitals, childcare centers, or disproportionately impacted communities within a mile. There are no high priority habitat wildlife concerns, and this location is outside of wetlands, floodplain, and any sensitive area for water resources. Although there are 2 residential building units within 2,000 feet, PDC obtained signed informed consent from both owners. The informed consents were obtained using the COGCC template and were obtained in April and May of 2021. There is also a non-residential building unit that is used by DCP for their compressor facility operations. This is located 1,875 feet southwest of our location. Although an informed consent is not required for this type of building unit, PDC did have conversations with DCP regarding our planned operations and gained their support for our location as well. Ultimately, this location allows PDC to drill 3-mile laterals for maximum mineral development contact from one surface location, eliminating the need for a second well pad in the area if shorter horizontal well lengths were chosen. Fresh water will be delivered via pipeline to the location in an effort to reduce truck traffic. Private agreements are in place for the purchase of this fresh water. PDC began the planning of this location prior to the recent tank light facility design discussions with CDPHE and is committed to evaluating the potential for efficiency and reduced tanks for this location. Any changes to the facility would only be more protective and would not create any additional surface disturbance or impact. We are currently planning on using Group 2 drilling mud, and cuttings will be hauled continuously throughout the drilling phase to an approved disposal facility. Traffic will be split 50% north and 50% south on County Road 29 to reduce any potential traffic nuisance. Continuous noise and air monitoring are planned throughout all pre-production operations. Sound walls will be installed, and lights will be attached to the interior of the sound walls and will be turned downward away from the building units to provide additional protections. A quiet frac fleet will be used for completion operations. This location will be monitored 24/7 via PDC's field monitoring room, and daily visual inspections will occur. Additionally, an automation tower will be installed on location for remote shut-in capabilities and site security. All in all, we are confident this is the most protective site along with the robust best management practices PDC has committed to. This location also adheres to all COGCC rules. Thank you very much, and we anticipate any questions that you might have regarding this oil and gas development plan. We also have Brian Coshier and Brian DeRose to assist with the questions.
Thank you very much, Ms. Chase. Thank you, Mr. Storm, for the overview. We will now turn to questions from commissioners. Can you explain or elaborate with regard to tanks, tank light, your approach with regard to that? We've heard about that, and we were on site at one of your locations, or I was, and just would like to get that out on the record.
Yeah, sure. Thank you, Chair. This is Brian Coshier. I think I can take that question. Through our cumulative impact analysis, we've had a comprehensive evaluation to address our impacts or evaluate our impacts and address it through robust BMPs. Reduction of emissions and minimizing impacts is at the forefront of PDC and how we operate. In addition to just regulatory or GHG roadmap goals, PDC also has very robust GHG and methane intensity reductions of 60 and 50% respectively by 2025 using a 2020 benchmark. So currently the Spinney facility as proposed has 2 water and 4 oil tanks. The water tanks in place are due to a lack of infrastructure for water takeaway. Currently the current infrastructure is about 10 miles north of where we plan to operate this facility. The oil tanks are for redundancy purposes and acts as maintenance tanks. So we are fully confident that our standard operating procedures for this facility is tankless for hydrocarbon production, meaning we have multiple phases of separation to reduce our pressures after we go through the initial separation and remove additional gas from our production stream. With that, through the 2-phase separators and our surge vessel, we also have vapor recovery units that then remove the gas from those units and send it to sales. So we are conservative in our approach of cumulative impact analysis, meaning we assume that 10% of the time that surge vessel is either down or for maintenance, and we go to the tanks. With that, we recover 95% of that gas and send it to sales. So I just wanted to point out that in actual real numbers, generally that's a 97 to 98% runtime for our surge vessel. So we do have the tanks for redundancy, for maintenance and upset conditions, but 97, 98% of the time we are tankless for our operations for hydrocarbon production.
Thank you for that explanation. That's very helpful for this commissioner at least. Do other commissioners have questions for the panel? Commissioner McGowan?
Wow. Sorry, I have trouble with the unmute button there. Excuse me. Thank you for presenting today and being the second to come in front of all the questions. So I have some similar questions that I had to the previous operator. One, which was, I wonder if you could, again, talk a little bit about, if I understand, of the 8 wells, 6 are within the drilling spacing unit, and then you're asking for 2 wellbore spacing units. And I'm wondering, again, why you just didn't set the drilling and spacing unit up to accommodate all the wells that you want, and instead you're asking for 2 wellbore spacing units. And I was wondering if you could explain that a little bit. I'll start with that question.
Thank you, Commissioner McGowan. It's a good question. Wellbore spacing units are really an effective tool for 3 reasons. First, they're an effective tool to appropriately allocate production to the appropriate owners that are entitled to probably share in the production from that well. They're an appropriate tool to comply with the Act, which requires that the wellbore spacing unit not be smaller than the maximum allowable area that can be drained by the proposed wells within those units. And they're an effective tool to capture the maximum amount of resource. And so as an operator evaluates the most effective ways to capture resource that might otherwise get stranded within the setbacks, wellbore spacing units are really the greatest tool for PDC to do that. They allow PDC to move into resource that would otherwise not be captured within a development plan. They allocate production appropriately to the owners that are entitled to share within that resource. And then they comply with the act in that when a resource might otherwise be left within the ground due to setback limitations and what the drainage calculations are, wellbore spacing units allow the operator to do that. And it was touched on by the prior presenter. The commission acknowledged that they still are an effective tool under the mission change rules, and that's why they were allowed to continue to exist in some form. You note that there's an alternative that an operator can seek a drilling and spacing unit that's larger, and in many cases that very well makes sense. Much of that is driven by the underlying leasehold and working interest characteristics that may apply to a given development plan. But in this case, it just does not make sense for protection of correlative rights and ensuring that production is allocated to the appropriate parties that are likely entitled to share in that well.
Follow up, Commissioner McGowan?
Yes, sorry. My cursor is not working with my mute and unmute, so I have to use my finger. My second question, and similar to what I asked the previous operator, it looks like as part of this proposal or application, you will be P&Ing, I think 33 existing wells, which I assume are either inactive or active. And I would be interested to know if we could get some sort of emissions reduction measurement or estimate from you as part of that, so we could start tracking for cumulative impacts.
Yeah, I think I can take that one as well. Yeah, so with this development, we're accounting for up to 33 wells to be P&A'd in conjunction with the development. We will work with an offset operator on those wells. It's part of our offset well evaluation for hydraulic fracturing, making sure that these wells are either sound, for surface equipment or sound for cement integrity. So it's already part of our process. And with that, we'll work on the timing of the retirement of those wells. I will say the only ask I would have is that, we're not going to be able to have real-time data associated with those emissions because, some of them may be shut in, like you mentioned, some of them may be active. But if we do go down the road of providing that, because we want to account for all impacts, both or all impacts both beneficial as well. That the emission calculation would be as per CDPHE approved methodology. Working in conjunction with the division to understand how we can account for those emission reductions from the wells that potentially will be taken or retired based on the development of the Spinney.
Great, I appreciate that. I think we really need to just start somewhere and not just keep talking about it. So if there's something that we could do with CDPHE in partnership to come up with some sort of measurement, I think that's at least a start. Yeah. So I appreciate that. My last comment, and I'm trying to think of a way that so as I think about where receptors are and where this activity is, I'm appreciative that you actually got signed consent from the folks who are most and closely affected. What I found a little tone deaf to me, and I don't mean that as a pun because it's under your noise plan, is the comment that there shouldn't be a lot of expected adverse impacts on the receptors because they're already kind of used to being near noise because there's a compressor station there. And I think that as we think about environmental justice issues, right, part of the point of environmental justice is when we start to pile similar things onto the same communities and there's this cumulative effect and it's negative. And so while I'm appreciative that you've come up with a noise mitigation plan and you're going to try to minimize the noise, I hope we never see language again that, well, because they already have a noisy neighborhood, a little bit more noise, they shouldn't make that much big of a difference to them, which is how I read that. And I assume that that's not how it was meant. I think it's really important for us to recognize that those folks are already dealing with noise and impact in their neighborhood. And if I was reading the application correctly, they're already at the decibel level that we find high in our commission rules. And so we're having to use a rule that allows you to go an increment above that during certain hours, which means they're already dealing with, I think, significant noise in their neighborhood. I hope I'm not mixing up applications. I hope this is, okay. So I will leave that comment at that, but I hope that we don't see language like that again, because it's really not very respectful of what's probably going on in that neighborhood for those people.
Yeah, and
see, yeah, go ahead, Mr. Koshier.
Oh, I was just going to say, you know, I apologize if that's how it came off, and we'll certainly, you know, make sure that approach isn't taken in the future. I think what we were trying to convey is that, you know, we have the 2 receptors, you know, outlined within our noise mitigation plan to the northwest and north, and that's where we put the, you know, we did an ambient survey prior to submitting the plan. So that's where we put the 2 receptors. We all, or 2 monitors, I should say. We also did put another monitor to the west, which is, you know, in direct vicinity of that compressor plant. And really, we're trying to understand, you know, the noise impacts from that plant, but then how that projects, you know, to those 2 receptors to the north and northwest. If I can try to rephrase that sentence in real time here, I think what, you know, the intent is that we don't anticipate really impacts from our operations, you know, to increase really above the ambient levels. And I think you'll see within the table, there's, you know, I think section 5 within our noise mitigation plan, there's a table that addresses, you know, the ambient surveys and the adjusted thresholds based on 423 or 434 D2 or 423 D2, sorry. You know, of those adjustments, and that we really don't anticipate, you know, our operations impacting really above ambient. And again, once again, I apologize if it came off wrong. I think that was really the intent of what we were trying to get after. But it is noted.
I note that Commissioner McGowan is nodding up and down, so that's affirmative. So thank you for that explanation. Looking around at other commissioners to see if we have other questions for the panel. Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you all for coming before us to help us understand some of the aspects of the application. I also have a similar question to the types of things that I was asking in the last OGDP, and that relates to the presence of the emergent wetlands that are in some cases within a few hundred feet of the site, if I understood correctly. And I was just actually looking through my notes to try to figure out where exactly I had read that, but it was in a section that related to the receiving waters, and there was a note about NWI mapped wetlands, national wetlands inventory, and that there were a couple of locations that were within a couple 100 feet. And I didn't see anything about secondary containment or other, you know, related mitigation for any potential spills or leaks or that kind of thing. And I may have missed it. With all of these materials, you know, I definitely try to read everything as closely as possible, but I'm sure I missed details. So if you can point out to me if I've missed where that is, that would be great. But just wanted to get some commentary about the proximity of those emergent wetlands and kind of what sorts of mitigation. It sort of seemed that they were somewhat disregarded.
Mr. Koshier?
Acknowledge the disregarded, sorry.
Brian, did you want to go? Or I can go over the BMPs. You know, we do have very robust BMPs in place within our fluid leak detection plan. You know, on the well pad itself, we do put a layer of cementation that was tested as impermeable under our, you know, where our drilling rig or, you know, hydraulic frac fleet will be performing the work. We also do have secondary containment outside of that cementation in the form of liner that goes under, any containers, holding fluids or chemicals, for pre-production. We do have secondary containment under our facilities as outlined within the 600 series. We have a very robust stormwater management plan that deals with runoff coming from the pad. So there's a few different places you can find it, but mainly like the fluid leak detection plan outlines that. I will also note that, with this facility, we'll have monthly LDAR inspections to further, detect any potential for leaks or any contaminations, and daily, audio, visual, olfactory inspections.
Thank you. I appreciate that. And I finally found where I had this in my notes. It was from the cumulative impacts plan.
Okay.
And under section 3.2 water resources. So there was sort of a note about, let's see, what do we say here? Increased erosion and subsequent increased sedimentation of intermittent streams and ephemeral drainages is possible, especially during construction and other surface disturbing activities. These effects could have negative impacts on aquatic habitat within affected drainages. The nearest receiving water body is a National Wetland Inventory mapped freshwater emergent wetland, classified as a palustrin emergent temporary flooded wetland, approximately 208 feet to the east of the Spinney pad. This wetland would be along the potential migration pathway from the Spinney pad, et cetera, et cetera. So that did raise a little bit of a concern for me, because as a mapped wetland, as I understand our definition of waters of the state, that would be included. And so I think there would be additional containment measures that would be required. And I'm just double checking now where we have this information, but I guess that would be something that I would have a concern about as well. I appreciate that you mentioned that there would be liners and et cetera around the tanks, but we just wondered if you could comment further on that. I think there was another section where, not in this plan, but in another place, maybe in the water plan, where it was sort of noted that there weren't really any wetlands nearby. And so it seemed like those two things were in conflict.
Sure. And maybe moving forward, it makes sense to kind of have a cumulative look at it. We did have the BMPs in various plans. Like I said, the fluid leak detection, the stormwater management plan, that address, how everything would be contained and prohibited from finding, the migratory path to that wetland. But if that's not addressed, then we can discuss further if needed.
Yeah, thank you. I think, and maybe this is a point to just ask, or when it would be appropriate to ask the staff the same question about their thoughts on the proximity to those wetlands and their considerations going into that. I had another question as well, and that also kind of relates to cumulative impacts with respect to the other wells that are already present in the area. I was curious, first of all, I noticed that there were several shut-in wells that are, I think, Kerr-McGee's in particular. I was curious if you had any conversations with them, or if there's any, or if any of those, or within a closer radius, if any of the wells that you're planning to plug and abandon are kind of in close proximity, just as it relates to kind of the overall cumulative impacts of this proposal.
Yes, so the 33 wells, that were accounted for, up to 33 that would be plugged and reclaimed based on this development are really within, the mineral acreage of the development. So the well bores are, intersecting the formations that we will be producing throughout that lateral. And I will say, especially with operators that, we kind of have intertwined acreage, or, that we deal with a lot offset, we have continuous conversations about offset wells, timing of development for new development, and how to address each well as we're going through to make sure everything's either protected or plugged and removed prior to hydraulic fracturing. So, the communications is just continuous, I would say, about every development, including the spinning when we get to it.
And correct me if I'm wrong, but I don't think that was, I believe in the cumulative impacts plan, there was discussion about the wells that were going to be plugged. But I just wanted to be clear. So it does not include any sort of negotiations with some of those nearby proximate wells or the ones that are in closest proximity. Is that correct?
Negotiations outside of that.
Sorry, with Kerr-McGee, with these conversations that you're having as it relates to offsets with your own activities, given that they're shut-in wells, I was just curious if any of that comes into play with your conversations about, or even considerations of wells that you might be considering for plugging and abandoning, or are they all just your own, under your own ownership?
No, they're offset operators as well. And really within those conversations is addressing, how will these wells be either plugged and abandoned prior to us coming in for development, particularly with hydraulic fracturing, or, we have a term called safety prep where, we make sure the integrity of cement's in line to handle pressures. We have, upgrade surface equipment. So all of those discussions, I think would be encompassed, including negotiations of how wells will be removed, are all in those continual conversations we have from operator to operator.
Okay, let me see here.
I hope that answered your question. If not, we can.
I think so. It's starting to get at it. I think I'll pause for now. I may have other questions.
Okay, I guess I'll just, all those offset wells within the mineral acreage development will be addressed prior to, the full development of the spinning.
Further questions, Commissioner Hackett?
Thank you, Chair Robbins, and thank you for the presentation. I did have a question, and apologize if I missed this from your submittals or your presentation today, but can you talk a little bit more about discussions you've had around electrification of this well pad? I definitely understand the challenges with pulling electricity, especially such a high load to operate drilling equipment, for example, to a rural area like this, but can you let us know what sort of discussions occurred around that?
Yeah, sure, Commissioner Hackett, I appreciate the question. And as we discussed in our consultations, we've had a lot of discussions with the electrical providers, for some of our larger developments, coming forth before, that'll be submitted in the future. But I would say as we've gone through this year, and adapted and submission change and really, focus on continual reduction of our emissions, that's a very large focus here at PDC, and it's really starting to become almost embedded in our planning and development programs, similar to what midstream was in the past. Now with this electrification, we are working with our providers to really outline our schedule and understand their capacity to meet the demands. So with that, I think one of the benefits that we have is that, we're projecting to drill this location, in April of 2023. So we have a year and a half, and we will continue those dialogues with the electrical provider with the goal of getting electricity to the location prior to drilling and continuing through our facilities. Now, I will also say that, within that cumulative impact analysis, or the Form 2B that was submitted, I said it was a conservative approach. So we assumed within that everything was, going to be either, diesel burn generator or whatnot outside of using line power. So that is our goal, to get electricity there. We will continue to work on that in the near term to hit that 2023 deadline. And, we evaluate it just like the tanks. We take conservative estimates, knowing that, anything that changes prior to the development starting will be more protective.
Thank you for that. I appreciate that, and also would note I'm definitely hopeful other operators are building in these electrification discussions as they develop their plans farther out. And then also just wanted to say thank you for that discussion about tank light facilities. And Commissioner Robbins, you stole my thunder there, so thank you for asking that question. That's all I had.
And Commissioner Hackett, if I can just add one more thing to the tank light. I know we've been discussing it with the CDPHE and the associated divisions about, us transitioning to a tank light facility, but like I said, really our hydrocarbon production is tankless, and we are generally capturing everything and putting it down the sales line. We do have, like I said, 4 oil tanks on this location, but we are considering a maintenance tanks, really for operational practices. But knowing, our continued collaboration, which we greatly appreciate, that as we move into the future and really start putting these things on the ground and implementing these facilities that we've been discussing, we're going to continue to evaluate to what makes sense to evolve into what either permits in hand or, retrofitting previous facilities. So, one of the things submitting these applications, year and a half, 2 years in advance is one of the benefits we have that was contemplated within the rule series is Rule 404, the ability to sundry, knowing that it's more protected. So we are always looking to minimize our impacts and really like our emissions reductions is at the forefront, and we will continue to work towards those goals. But we think, the plan we have forward is really protective and achieves what we were looking for with the emissions reductions from utilizing tanks.
Thank you, Mr. Cocchiere, for that elaboration. I do note that Ms. Trask has daylighted herself, and I don't know if she wanted to answer any of the questions that have come so far. Love to hear from you, Ms. Trask.
Thank you, Chair Robbins. Yeah, I wanted to circle back to Commissioner Nanjapa's question about the nearest emergent NWI mapped wetland that's a few hundred feet away from the proposed location. This emergent wetland is represented in the applicant's hydrology map, and staff did take a close look at that. We've determined that emergent wetland is cross gradient or possibly up gradient from the location, and so we don't believe that there would be a migration path in the event of a spill or release from the location to that wetland because of the gradient of the slope in between.
Follow up, Commissioner Nanjapa.
Thank you. I appreciate that, Ms. Trask. And I saw what you mean. I saw the wetland that was mapped on the hydrology map. And I can see a couple on the aerial, photography in Cogcc and even in the location map, that are a little bit further away. But there's some areas that look like they could be what's being referenced that's more like a couple of 100 feet away. I guess, well, maybe the question more then is I just wanted to make sure that I am getting all these details straight. Are there going to be, you did say that there were going to be some storage tanks while you are moving towards the tank light facility, correct? And so I guess, and I know you already mentioned that there would be liners underneath those sorts of storage tanks. I think I still have a little bit of a concern, especially with one of them being as close as 200 feet away. So I'll just voice that concern for right now.
Okay, other commissioners or Commissioner Nanjapa?
Sorry, just to follow up. So another thing I noted was in the dust mitigation plan, there was the intent to use magnesium chloride. I was just curious why that over other forms of dust mitigation, and my concern relates to the proximity of the wetlands.
Magnesium chloride, I guess, is more of a standard practice, particularly in the county, and we put that on our access road really to eliminate dust, but also for the integrity of the road and its longevity to, have, a road that doesn't erode, but also doesn't, impact with fugitive dust.
Okay, are there alternative options that you might be able to consider?
I would say not as effectively with dust, right?
I mean, I know in some other instances, it's spraying water or,
And we do that in addition, but really Weld County requires this and uses
Oh, I
it
see. Okay.
on, not only county roads, but requires it as part of their mitigation for dust and integrity of the road. We do spray, water around our well pad during, pre-production activities to mitigate dust on pad. But really the road is a county requirement that we kind of defer to Weld on.
Okay, thank you. I appreciate that clarification.
Other questions from commissioners? All right, I'm giving you sufficient time to look at your notes to make sure you're all good. It looks like we're in a good spot right now. Anything further from the staff, Director Murphy, Ms. Trask? Okay, then I think at this point we will thank PDC and staff for being available and presenting to us. It looks like we have the answers to any questions from our review of the application and the file, and we will allow them to be removed from the panel. And again, thank you for your presentations. Give us a sec here. Okay, commissioners, at this point, I think we need to consider whether there are any additional items that are necessary for this application, where people may be sitting with regard to this. It is on the OGDP consent agenda. What are folks' thoughts? Commissioner McGowan?
Thank you, Mr. Chair. Only that I would appreciate consideration of a condition of approval related to emissions reduction estimates. And it sounds like they're open to this, maybe working in partnership with CDPHE to figure out how to determine what that number looks like for cumulative impacts.
Very good. Other commissioners with thoughts? Commissioner Messner?
I'll just give some brief thoughts that, I thought, again, this was a well-done application. I think it appears that they worked closely with staff, implemented general best management practices. I appreciate that they received informed consent from the RBU tenants or owners inside of 2,000 feet. That provided, in my opinion, the ability for those tenants or owners to determine whether or not the BMPs were substantially equivalent for their particular situations. And so in this particular situation, that's probably why you didn't hear me ask a lot of questions, because I was able to discern a lot of the other information from the application, and they did have that informed consent. So to me, those are some of my thoughts.
Very good. Thank you, Commissioner Messner. Do we have a motion? Commissioner McGowan, I'm looking at you perhaps for a motion because you've got your extra condition.
Thank you, Mr. Chair. So I move, oh my goodness. let's see if I have in my notes the number that they are. The PDC Energy Spiny application with a condition of approval to work on emissions reduction estimates with CDPHE for the peeing of up to 33 wells in the same area for approval.
Motion, do we have a second?
Second.
We have a motion and a second. I have a little discussion on this one. I just want to say that I think this is a strong application for 8 wells in Weld County. I am appreciative that it has received Weld County approval. I'm appreciative of the fact that there is informed consent from all the nearby residences. I think the application shows PDC worked closely in Weld County and with other state agencies. I note there were no variances or exceptions, and there was a robust ALA that was targeted here. I am in favor of the application. I'm in favor of the application with Commissioner McGowan's condition of approval. I think it's a thoughtful approach to permitting and responsible development, and it's a good example of how this can work in Colorado. So those are my thoughts. Others with thoughts before we take a vote? Commissioner Nanjapa, then Commissioner Hackett.
Thank you, Mr. Chair. I generally agree with the motion and with your comments, Chair Robbins. As already voiced, I have some concerns about the proximity of those wetlands. I do understand and see that the likelihood of down gradient movement is low. So to the extent that PDC can maintain their containment and just be just following their fluid leak detection strategies would be appreciated, but also agree that it was a very well done and thorough application. The ALA process was very thorough, and definitely appreciate that they got the written informed consent from the residents within the 2,000 feet. So I'm supportive as well.
Thank you, Commissioner Nanjapa. Commissioner Hackett.
Thank you, Mr. Chair. And just wanted to follow up, maybe get some clarification on the condition of approval proposed by Commissioner McGowan. Understand that you'll be encouraging PDC to work with CDPHE on emissions reductions estimates for plugging and abandonment of wells. So it seems like the onus in this case is on PDC to engage with CDPHE and not vice versa. Okay, I'm seeing some heads nodding there. So yeah, we'll be happy to provide whatever support we can with our resources. And I did just want to note within the Air Quality Control Commission's regulation number 7, Part D, Section 2G, that has information about what operators are required to do when plugging and abandoning wells. It does require that they implement best management practices. Unfortunately, the rule itself does not dictate or mandate what specific BMPs must be used, and CDPHE does not have guidance for what what BMPs must be used there. But anyway, just wanted to make sure folks were aware of that, and we look forward to engaging with PDC on this.
Thank you, Commissioner Hackett. I appreciate those comments with your CDPHE hat on. Commissioner McGowan.
Thank you, Mr. Chair. Just to clarify, I thought I understood PDC saying that they'd like to work with CDPHE on this. I'm assuming because work down the road is probably going to involve coming up with emissions reduction estimates from peeing and A-ing wells. So I'm not trying to force anybody into a relationship they don't want to have, but that's what I thought I heard Mr. Cucchieri say. So that's why I made the motion the way that I did.
I agree with you, Commissioner McGowan. That's what I heard too. Okay. I'm seeing no further discussion. We have a motion that has been seconded on the table. All those in favor of the motion signify by saying aye.
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 Any opposed? The motion carries unanimously 5-0. Very good. Thank you for that, everyone. At this time, we are about to the end of our agenda. We did commissioner comments earlier, but we can do it again. Does anybody have additional commissioner comments for ourselves or for the good of the cause or for the agency or otherwise? Oh, wow, lots. Okay, I saw Messner and then McGowan and then Gonzalez.
Thank you, Mr. Chair. Just a question, really, because I don't have enough to read and there's nothing good on television lately. I read the big game policy report that was submitted or that was provided by the governor's office a few days ago. In that report, it seems to task or indicates that COGCC has some responsibilities along those within the report. And so I guess I was a little curious if, and it doesn't have to be today, but at some point we could chat a little bit about that report and what action items should be on COGCC's plate associated with that report.
Very good. I think you just gave direction to the director and staff. So,
okay.
Duly noted. Yep, there she is. Got it. Okay, Commissioner McGowan. Unless you had, did you have other, Commissioner Messner?
No, that's what I had.
Okay, Commissioner McGowan.
Thank you, Mr. Chair. You will all see an invite on your calendars for October 18th for an educational docket around biochar. I think I let you all know that I was working on that, so I'm super excited to talk about the potential uses. And it will be a late afternoon into early evening meeting because we have speakers from New York and potentially Singapore, and their time zones are like diametrically opposed. So we're gonna try to get someone up really early and keep someone after dinner to hear from the speaker. So I appreciate your willingness to kind of have an off time kind of commission hearing or educational docket. Thanks.
All right, you get the award for inviting speakers from the furthest away after the good water docket we just had. Commissioner Gonzalez.
Thank you, Chair. I wanted to reflect a little bit about what we heard today in terms of the OGDPs that were presented to us. I thought they were a really good example of just a thoughtful approach, a thorough approach to applying our new rules, and really kind of demonstrated a really strong baseline for what I'd like to see from applicants going forward. I think that that we're going to continue to learn, have an iterative process as we work through it. But I think that the ongoing dialogue with stakeholders, with staff, and with us commission is extremely important. And I thought that was well demonstrated today with the two applications that we had. And so I just wanted to acknowledge that I think that this is an example of how the work that we did last November is coming to fruition in a way that's workable and in a way that that's hopefully going to be get good results for the state in a protective way. So I appreciate everyone's preparation of the materials leading up to this, including staff, and just wanted to share that with our listeners today.
I thank you for those comments, Commissioner Gonzalez. I agree with those comments. I also think that these coming to us are starting to sort of daylight the behind the scenes work that is happening, and I think that lessons are being learned, and that the process is likely to have less unintended hiccups as we move forward. And I also want to thank the staff, the permitting staff in particular, for the good hard work that's being done here, the director for the director's recommendations, which I hope thinks focus in on our review, on our stakeholders review. And I, again, appreciate and agree with you with regard to the work the two operators put together here. So good place to end, I think. Unless there's other commissioner comments, we're looking for a motion to adjourn.
So moved.
Second.
We have a motion and a second, and seeing no further discussion, all those in favor signify by saying aye.
Aye.
Aye. Any opposed? None. We are adjourned. Thank you, everybody.